Yes.
Lordship, I want to withdraw a writ petition on Monday.
Our prayers for listing, please give it to the courtmaster. Our prayers for listing, give it to the courtmaster. They may have to be make adjustment for 1 or 2 days, but he'll do it.
May I please, your Lordship?
Yes, yes.
Lordship, I am praying for an upgradation. Item number 61, 62, 63. It's related to tender matter, Lordship, and the season for sowing is only till July. Lordship may take it up at 2, Lordship.
Okay, I'll try to upgrade and take it up. You inform Mr. Buragwani?
Yes, my lord.
So you're there. Okay.
I look at 2, my lord. Yes.
Yes.
I beg to mention admission item number 44 and 45, Lordship. Let it come up after vacation with the consent of the other side I am mentioning.
Okay. 44, 45.
45. And for the department.
Lordship, I'm from the petition.
Okay. Great. Both sides are duly represented on the prayer made by Mr. S. Sithial and its standing counsel for income tax. List after entering summer vacation.
Lordship, there's an interim order.
Okay, interim order passed today stands extended till the next date of listing.
May it please your lordship.
Yes.
Your lordship, I am praying for listing of a matter today. I know your lordship had said that I am only praying for listing of matter today, so I am making a mention. Though your lordship has just now said not to make any mention.
What is the urgency?
This is a matter relating to eviction by the bank.
Okay.
At today after the motion or at 2?
It will come whenever it comes.
Oblige.
Item number 41 of today's business, admission matter. Considering your lordship's list today, can be taken up on Tuesday minutes.
Tuesday, I'm not taking up any matters. Monday, Wednesday, and Friday. Tuesday, these 3 days.
So it's a tender matter. There's some urgency.
On these 3 days, you take a chance. Not on the hearing day.
I will take together.
May it please your lordship. Lordship, in item 27, we have filed an affidavit in opposition, lordship, yesterday. So kindly it may be called for.
Get it.
Okay.
May it please, my lordship. Item number 42. So kindly adjourn the matter for the day.
For the day.
Yes, my lord.
Okay. Pass over the day as paid for and counsel for the petitioner. Okay.
42.
Yes.
If I may please, your lordship, I'd like to mention item number 70 from the supplementary list for German. We've taken consent from the other side, and the interim order passed earlier may be continued. Matter may be listed after vacation.
Item 70, hearing. Okay, the list in the next week as per paid for by land counsel for the petitioner. Interim order passed today stands extended till the next date of listing. Yes.
May I please, your lordship. Item 67, I pray for upgradation.
67.
Yes, at 2.
Not at two, I have a fixed matter. But I'll take it up. I'm not giving a time, but I'm take it up. 67.
Supplementary opposition item number 58 for the
May I please your lordship.
Okay.
Lordship, in this case, your lordship last order has been instructed, so I want to.
Okay. Upon instructions, Mr. S.I. Akan, counsel for the petitioner, is to allow him to withdraw the contempt petition as the matter has become infructuous. Mr. R. Pujaris, counsel for respondent number 1 is present. Another stand dismissed on withdrawal.
Oblige.
Dismissed on withdrawal.
deeply over.
Yes, item 1.
Miscellaneous item number 1 for motions.
Yes, you had not contested the matter.
Contested in the sense, it's been recorded as not contested.
Where is the order?
The page 48, you. Only comes
And
in
where is that advocate's, what do you call the medical certificate?
he's given this. Page 52 only.
For the respondent,
Yes, Lord.
this order would not be sustainable. You see, a person can go to a doctor, but how the doctor will write a prescription is his prerogative. The court cannot say that he, in the clinical note, he did not write that he saw the patient.
I have not received any copy of the petition.
I said, give him a copy. He's
Yes,
there,
sir.
give him a copy. Otherwise,
And some time will be given for filing an.
we take it up on Wednesday. Because last week I have to keep myself free. Otherwise, you can't do anything.
Lord, Friday. I will be out of station on 3 days.
Okay. Friday, okay. Give her a copy. Mr. M. Z. Ahmed and counsel, senior counsel, assisted by Mr. A. Datta and counsel for the petitioner, as well as Ms. M. Dev, learned counsel, was entered the appearance for the sole respondent. Next, let a copy of the petition be provided to the learned counsel for the respondent. Please again in the motion column on Friday.
23, yes.
But Mr. Ahmed, whatever the court is otherwise done is okay. Because we are now getting too harsh on the trial court judicial officers on adjournment. So I'll be partly sharing a blame of the trial court closing the matters, but
Not in this manner. Close it, but not in the manner done here.
no, it can't be helped because if because of the law, the trial doesn't proceed, it has to be done.
There were reasons for not appearing.
No, I understand, but you see, I see the condition of both of you, correct? She is having immense physical problems. and you are also having, correct? But the thing is that how much time can the matters be adjourned on that count? Because both of you will, I'm just, it's a personal note, not, it's not intended to harm, what you call, to annoy or to, what you call, hurt you. But the fact is that you see, these are things, you see, even I am wearing this, what you call the belt and, what you call, I'm sitting here with a belt because I have immense, what you call, pain in the, in the lumbar. There's a severe pain for slip disc, L3, L4, L5. But I have to do it.
Yes,
It's a work of choice. So therefore, I can't delegate it to another person. But for a lawyer, they have to train up the young members of the bar and then have the matters done. Because there are few good practices. I'm just wasting the time of learned lawyers, but I can just tell you only one thing. I've long back, 20 years back, visited Visakhapatnam for a matter. And I saw their very unique system of the bar. Young juniors who are just fresh in practice. In that bar, in bar there are several tables, and attached to every table, whoever the seniors are. So these juniors will be there in the room, and they will just ask which court. So they will say that, okay, I'm in Musif 1. Somebody will say I'm in CGM. So all these juniors, they are given at that point of time, they were given 10 rupees to give the roll call. They don't have Hazira there. The judge records roll call. First about 45 minutes or 1 hour is taken on roll call. Who are present, witnesses are present, those are recorded. And each junior gets some money. So at the end of the day, there is a high litigation. At the end of the day, the juniors, very fresh juniors, they get a good amount with and they are satisfied. So they are assured of an income. And in the meanwhile, they have started interaction with the court just at the entry level. So that is how they are grooming up young boys and girls there. I find it very, very, very useful. I was very impressed. But in this region, we are not encouraging that. So they are training up juniors like that.
That is only for role calls, attending the case. But for adjourning, you know,
No, you see, that is what I'm saying. Once an interaction starts, the juniors will grow up.
That's
Juniors will grow up. So I'm sorry I've taken time of the bar, but this is something. We'll take it up on Friday.
So there should not be any construction.
With the 7 days, I don't think anything will happen.
Keeping stones in bricks. No.
Yes, construction is going on.
no. It's not his land. I will show everything, Lordship. He's claiming there is my entitlements over the land, Lordship.
We'll do it because otherwise we'll make ask them not to make it, because otherwise we'll
Yes,
have to pass
It
an
is
interim
not
order and get that.
not their land.
No, may not be, but once there is a litigation on a
Yes,
land,
Lord.
ask them to restrain themselves. Yes, item 2.
Item number
Obliged.
It's a case of a missing award. There was 2 land acquisition cases against the Crown with regard to a land which the oil wanted to procure. There are a number of litigations where here, my lord. The last litigation, my lord, this honorable court remanded back the matter, directing the deputy commissioner to find out whether there was an award or not. The deputy commissioner now has passed an impugn order, my lord, which my lord would find at page 155.
Please come to the High Court order first.
Lordship, my lord will have the High
Because
Court
this-
order. It starts at 140.
With 24(1)(b) and all, I could not follow it.
Lordship. My lord will have 150 para 13. My lord. It starts
150.
at 150. It's an order dated, my lord, 2/3/23. If the deputy commissioner upon perusal of his own records can find out whether there exists an award which can be made under section 11 of the Act of so and so, the provisions of section 24(1)(b) of the Act of 2013 would be applicable, and in such case, wherever award is available on record, the same has to be brought to its logical end, meaning thereby that the beneficiaries of the land would have to make the payment of compensation of land to the landowners. If on the other hand, no award can be found by the deputy commissioner from the records, which may have been made under section 11 of the so and so, the provisions of so and so would be made applicable, meaning thereby that the provisions of the Act of 2013 would be applicable in respect of compensation that is to be made to the landowner, namely Nandalal Sons and Tea Private Industries. Then, my lord, according.
But just a moment. You see, but is it not the case that if the award is not made, then the award itself lapsed?
There is a
proceeding
mistake.
itself lapsed.
There is a mistake there. Our case was the award was made and the possession was taken away. So, my lord, in terms of, my lord, the second part of that act, my lord, this will not apply. 24(1), 24(2), my lord.
But where is that? What is the
That,
date
my
of
lord,
award?
unfortunately, while there is a typographical error here, my lord, would come to the next page, my lord.
Yes.
14. Accordingly, we direct the Deputy Commissioner to look into the records and arrive at its own fair conclusion. In the event an award under section so and so, the implication thereof be followed, so that the landowner receive the appropriate compensation for land that had been accrued. And if on the other hand, the Deputy Commissioner Tinsukia arrives at his conclusion, no award has been made under section 11 of the so and so, the provisions of 24(1)(a) be made applicable and the process be brought to its logical end. If it is 24(1)(a), my lord, then the Act of 2013 would come in, my lord. So what happened that, but the first thing was a determination whether the award was there or not. Now the order is at page 155, my lord.
Yes.
My lord, would then the
What is this? What do you call the last matter, which was heard by the three-judge bench of Supreme Court? Indore.
Those, my lord, these things have now been settled, my lord.
No, in that case, what does it say? If it is assuming that it has lapsed, it will be entirely a new exercise.
New exercise.
It's not only calculation of award
It
under
has to
24.
go afresh, man.
Afresh.
It has not gone here.
Okay.
It has not gone here. What have they have done, my lord? This is the story they have read out, my 155, 156, third paragraph, my lord.
Just one. Yes.
Here, my lord, in 2017, they had also proposed forwarded an award. I'll show that, my lord, which was under challenge, then that was set aside. My lord will come to 158, man. Whereas
Just a moment. Yes.
my lord would have 158.
Yes, I'm there.
Whereas the proceedings in alien number so and so are not disposed, neither any payment as ordered by the deputy commissioner has been deposited in the account of so and so. As such, land acquisition proceedings deems to have lapsed as per the provisions of section 24 of so and so. In view of the above, it is decided upon that no award passed in LA case number so and so as per section 11 of the LA Act 1894, and then he proceeds to, my lord, determine the compensation under the 39. Now, if your lordship comes to 116, the same very deputy commissioner. Now, my
What
lord,
is, what is wrong? Every day you wake up, it's a new day.
but the fact in existence, my lord, the existing fact cannot change. Interpretations may change, but an existing fact cannot be changed by the same very authority.
Okay.
My lord will have 116. My lord.
Yes, I'm there.
My lord will have the second paragraph. Whereas both parties have submitted their respective written statement in support of their claims and objection in regard to the value of the land as determined in the instant relay case number so and so, and examining the case records and land acquisition case number so and so. My lord will mark these words. And examining the case records of land acquisition case number so and so, the Oil India Limited had not deposited the award amount till date, whatever be the amount, nor asked any time for depositing the award amount consistent with the records of that the Hukanpuri had not received any amount of award, and hence as per provisions of so and so decided that since so and so has not deposited the award amount as per section 11 of so and so, hence the proceedings drawn under the provisions are hereby deemed to lapse. In this context, the views of the government by God has also been seen. Now, on one hand, in 2017, you say that the award which was made under the
No, just come there.
Lordship,
This 155 you were reading.
Lordship,
You please come there once again
Lordship,
and come to turn over to page 156.
Lordship. That is 15.9, my lord.
156.
56, third paragraph,
153rd paragraph.
15.9,
Yes, 15/9/17.
17. This
No,
is my lord.
no. Let me read it. Whereas Deputy Commissioner Tinsukia, while letter dated 15 September 2017, submitted the award proposal of LA case to the government for approval.
Lordship.
Now, if you come to LA Act,
My lord has the 89.
11(1),
Lordship,
there is first proviso, there is a second proviso.
Lordship, provided further that it shall be competent for the government to
No,
direct the
for first proviso.
provided that no award shall be made by the collector under this subsection without the previous approval of the appropriate government or such other officer as the appropriate government may authorize in this behalf.
Yes.
So, my lord, the estimate, what was there?
No,
No, award also to go. Estimate documents we have, man. That was approved by the government. And therein, my lord, there is a, while forwarding it, there is a serial number 1 order. Page 101, my lord would find it.
no, that is why I said I couldn't follow it.
Now, lordship, my lord, this matter, my lord, before what exactly the facts are, my lord, we beating around the bush, my lord, like this, I will be also not be able to take my lord anywhere. If my lord can have the direct the government to produce the records of LA 92 and 192 and 193, and from there, my lord, if they can show this, and then on that day, my lord, they can take a call. If it is not there, it's not there. And if it is there, my lord.
But whatever the original award is, that
What
you
is-
have to deposit 6 crore something. That amount you have to deposit.
We have deposited 1.5 crores already.
No, there's six original
No,
award
no.
is of 6
So
crore
after
something.
that, my lord, we have deposited 1.5 crores. It's on record. 1.5 crores we have deposited to their
No, no,
PFUs.
you see, now the question is, I forgot the award in this.
Lordship.
Yes. So, it will be enhanced exponentially, right?
Lordship.
But the original award, at least that you have to deposit.
My lord will come to page 97. My lord, it is 39,26,405 and page 101, 5,90,094,812.
No, I
5 crores.
read something 6 crores
My
something.
lord, both together will be 6 crores.
Huh.
So that amount,
you have to deposit.
Lordship. And my lord, we have already deposited the amount of 1.5 crores.
That will be adjusted.
That will be that much, my lord will say, then my lord will give you.
Yes.
After bringing up that, but see, if losses fix the record losses, from there we can find out whether award has been made or not. Otherwise,
No, award always is made. What happens is that only the approval is required. This approval, once approved, that is the award. In Assam, subject to correction and whatever you submit, I have not seen in any case that post approval an award is made. This is something I have not seen. I find that the award is made and sent for approval. And once it is approved, that becomes an award.
It is obvious.
The act says otherwise. Act says that it will only be an estimate which will be sent.
Act says award has to be prior, previous approval. Act is also very clear. It requires previous approval.
But here it's not that being done. The award is being made. And then award itself is sent for approval and the government approves it. This is-
Intention is there is no award, but I'll make good when. my
No, it's
turn
okay,
comes.
but this is my experience, subject to correction, because what I did was 20 years back, hardly.
No, that's the position. Gilapukri also, Malad, same thing happened.
I don't
Then
know.
it went up to the Supreme Court. Malad.
20 years is a long time to remember everything.
Case number 156 in the middle paragraph, also it is specifically stated that no award has been made under section 11 of the Land Acquisition Act 1894.
No, it can't be. Because you see, third paragraph says, submitted the award proposal to so and
So
so.
and so.
So that award proposal, once it transfer, once the government approves, becomes an award.
No, but that is the subsequent one. 2017, that is subsequent one.
Okay.
We are with the 2011 one.
Acha, okay.
Page 100, my lord, the 11, the sign estimate was signed, and I say that, my lord, the award was also. Be that as it may, my lord, the
11.
order that my lord would propose.
No,
100.
Page 101.
101. 101. Estimated. 590, and my lord, here it would be 39,026.
Which page? Which page?
My lord, 97 and 101.
700.
My lord, and 138, my lord.
So much volume is a deterrent to the.
But it will boil down to that point only, my lord. And whether the fresh proceedings have to be done or not.
Okay.
And 138, my lord, the deposit of 1.5 crores.
Here, Mrs. Goswami, what she has to say.
Only one thing, Lordship, section 24 of the new act, Lordship, subsection 2. It is not only approval, Lordship, the compensation amount has not been paid. So merely, Lordship, the issuance of notification will not suffice if it doesn't take the possession and the award has not been paid. There means it is not been credited or deposited to the landowner's Lordship. So that part is.
The possession is already with me, my lord.
Right to fair compensation. Okay.
Maybe the Lordship. Lordship, facts are not that complicated. I'll just indulge me, Lordship, 5 minutes and it'll become very clear what's happened in this case. 2000, they took possession, undisputed. So they have taken I'm for respondent number 5, the landowners, original landowners. They've taken possession of the land in 2000. Initially, it was under Assam Land Revenue Code. Then we filed 4 writ petitions before this court seeking compensation. Seeking compensation because they were not giving compensation. They just gave compensation for some destruction of tea bushes, etc., but not proper compensation. We came to this court. Lordship, the first order is of 2011 at page 74. Lordship, may kindly take a look at that page. It's important because we came to this court and at para 8, there was a direction that you initiate and complete land acquisition proceedings under the Act. So as of 5th April 2011, there were no proper land acquisition proceedings. After that, there was a meeting. Which meeting, 3 parties, respondent number 5, oil, and the deputy commissioner. The zonal valuation was pending. So they came about an interim payment. Because the zonal, Lordship, kindly take a look at page 91 and it'll become clear. So there was zonal valuation pending, which is why they came about, they agreed on an interim payment. Page 91, Your Lordship. Lordship, the second last paragraph. And Lordship, remind the date. It's 3rd May 2011. And the High Court order is 5th April 2011. So 5th April 2011, as per direction of the High Court, they were supposed to proceed with the land acquisition proceedings under the Land Acquisition Act. After that, this is the order. 3rd May 2011, second last,
High Court order is dated.
5th April 2011. We moved it for compensation, and then there was erection,
Just come again, 5th.
5th April 2011. Possession 2000, Your Lordship. So we came to court in 2002 asking for possession, for compensation. And that was heard in 5th April 2011. After that, that's at page 74, Lordship, for your record. After that, at page 21, you'll find the DC order, which is 3rd May 2011. And Lordship, the second last paragraph. It records, whereas as per tripartite meeting dated 30th April 2011, DC Tinsukia, both parties agreed to abide by the order of the DC for enhancement of land value in so-and-so T estate as an interim measure pending approval of the zonal valuation report by government. And Lordship, we turn over page 92. The amount fixed as an interim was 10 lakhs approximate per bigha. So this was a value agreed as per this DC order as an interim pending zonal valuation. And the last paragraph states any enhancement at a later date after zonal approval will have retrospective effect in this case, provided oil has not yet done the payment to DC. So this is the position. This is how it is on 3rd May 2011. After that, Your Lordship, the notification comes, section 4, which is at page 83, but Lordship, the date is important, 20th May 2011. So this interim measure is before a section 4 notification. So this interim measure, page 83, Your Lordship.
Yes.
So 3rd May 2011 DC interim measure award is before a section 4 notification. So it cannot be an award. You can't have an award before section 4. So Lordship, that is the first thing. After that, at page 108, which the learned senior counsel pointed out, 16th August 2011. That's at page 108. What they did is they extrapolated 1 bigha to the entire land and came to a cost of 5 crores and 39 lakhs. So 16/7/2011 at page 108. Your Lordship has page 108, Your Lordship. This is nothing but a continuation of 3/5/2011. The 10 lakhs per bigha becomes for the entire land 5 crores and 39 lakhs. This also can't be an award because this is the consequence of 3/5/11, which is before the section 4.
This is 16 July 11.
Yes, Your Lordship, page 108. And this doesn't do anything. This, what 3/5/11, which I showed Your Lordship, the 10 lakh is per bigha. So the per bigha for the entire land comes to 5 crore, 90 lakhs and 39 lakhs. That's all that 16/7 does. This is a consequence to 3/5/11. And after 3/5/11 is when section 4 comes into being. Now, Your Lordship, what is interesting is we still don't get compensation. So we had filed in 2002. We got that order from the High Court. Go ahead. We still don't get compensation. We come in 2017 for compensation and they challenge this 16/7. The petitioners challenge this, what they're relying on, and say this is the award. 16/7. This is not the award. It can't be an award because it came before section 4. Now, Lordship, I need to take a page.
This is after section 4.
Lordship,
16 July.
16/7 is nothing but a continuation. Lordship, 16.
It's okay. That is a question of interpretation because you see.
Lordship, 108. But Lordship, I don't even need.
No, I'm just telling what is in the mind.
Yeah,
You see,
sorry.
what is happening is that just before the acquisition, there's a meeting of mind, and all three parties have agreed that this will be the compensation, and if there's an enhancement, that will be retrospective.
Lordship.
Now,
This is independent of a land acquisition proceeding because it happened before. 3/5/11 is before. 3/5/11 is before, Your Lordship. 3/5, that's the important point to remember. 3/5/11 is before 2511, which was a section 4 notification.
No, it can't be. You see, come to page 91. under rule 189 and 190
Yes,
of the
Your Lordship.
rules under the so and so.
Yes, Your Lordship.
Now you see, you have land revenue regulation with you. I'll send you one.
I can.
Because under 189 and 190, the requirement is that if the, just see that rules, not the regulation itself, rules under the
189,
regulation,
189.
189 and 90 of the rules.
Anand.
119. Look, wasn't it?
Yes, Your Lordship. These are actually rules for prospecting license and mining lease.
Yes, and then come this 4. The deputy commissioner may assess or cause to be assessed any damage or injury which will be done or license so and so, and pay amounts to assess to the occupier.
Yes, Your Lordship. Lordship, that is what happened in the first instance.
Huh.
So Lordship, I'm obliged. Lordship, 2000, when they took possession, they determined compensation under section subclause 4, which you just now, Lordship, showed me. So they just did that. Then we came to court in 2002, saying that, sorry, you've taken over my lands, you need to compensate me over and above this land revenue code amount.
But what has happened, but otherwise.
No,
No, not that. I'm not saying anything against you.
Yeah.
You see, what has happened, but otherwise, land acquisition itself was not required.
But Lordship.
For the, what has happened.
Yeah,
I can't undo it.
I
We
see.
can't undo it.
No, because I think the reason is because then land acquisition brings in market value of the entire land, not just damages. And that market value, if you see Lordship, section 23, it includes damages, etc., etc.
It's okay, but I'm just referring to this scheme.
Lordship, you're absolutely correct. So that was our problem. We came to court saying you've taken over this and you've just given us money for damages to the bushes. And thereafter, thereafter we came to court, and this court then said, sorry, you go ahead and complete within, initiate and complete within 6 months. That is, Your Lordship, I showed you 5411. The 5411 is the starting point of land acquisition proceedings as per High Court directions.
You have made out a case. It's okay. But ultimately,
No,
in
Lordship,
the motion stage,
Lordship,
in the motion
now,
stage.
last occasion when it came up before this court, they have not been able, the court said, in fact, there's a finding, Your Lordship. May I just take 1 minute? Lordship, there's a finding that this 3511 is not an award. Para 11, page
Well,
147.
it can't be now, it can't be. You are right.
Yeah,
It
yes, Your
can't be.
Lordship.
Now it
Now,
can't be.
what is the law? Lordship, page, section 24. And Supreme Court makes it very, very clear. The Supreme Court says, how do you read Constitution bench? How do you read section 24? Section 24, first clause. If there is an award, if there is no award, in a situation where there is no award, 24(1), the new act. Okay, but the Supreme Court, para 187 to 198, it clarifies that doesn't mean the acquisition has lapsed. It means only that there is the award will come in under as the proceedings under new act, old act will continue. Compensation will be under new act. That's number one. Number two, when there's when there's already an award. Number one, when there's no award. Number two is 24(2) is when there is an
No
award.
award then lapsed.
No, when there's an award, old act. Simple. 24(2) doesn't say anything. 24 subclause 24(1)(b) says that if there is an award, then you go whole hog to the old act. 24(2) makes it a caveat to 24(1)(b) and says, but if the award is 5 years old on the date of when the new act came in, and two conditions have happened, that means the state has not bothered taking possession nor pay compensation. And Supreme Court reads or as and says if these two things have happened and the state has not bothered, notwithstanding that there is an award, it lapses. That is the only time when a land acquisition proceeding is lapsed. That's 5 judges have clarified it. And then the 5 judges have said, but there's a proviso to this one also. Even if one of the two is not met, then compensation will be under the new act. So our contention is there is no award. If there is no award, we are clean 24(1)(a) new act. Proceedings doesn't lapse. That Supreme Court 5 judges is very clear. Proceeding doesn't lapse. It continues Just the new award will come in the new act and compensation will be the new act.
Readily, I can't say the citation, but I
Yeah,
think
I have the-
66 or 67, there's a Supreme Court judgment saying that the, what you call, even if it lapses, a new notification can come, but that was dealing with the old act.
11.
And it says that the ownership will not revert back.
Correct, right. In fact, it has relied on those sections. Justice Shah has relied on those sections to
Okay.
say that two conditions why it lapses because possession is taken over.
Ah,
If possession is taken over, as your lordship is saying, correct, it can't come back, in which case it's lapsed. But if possession is taken over, but no compensation paid, then there is no lapse and compensation will be new act. So in two situations, there'll be new act. One is 24(1)(a), which is our clear case. There is no award. 24(1)(a) is clear. There is no dispute. If there's no award, just go new act. But proceedings don't lapse. That the Supreme Court has made very clear. And even if 24(2), there has been an award, 5 years have passed, you've not done anything. But if you've not paid compensation, even if you've taken possession, which is our case, I'm assuming there is an award, as they are saying, even then compensation is as per the new act. And lordship, what has happened? 2000, you've taken my land. And it's 23 years. We came to a court saying that we have no money and we're having a lot of labor problems. They did, the court at court's direction, they got us to deposit. They deposited in the Provident Fund. We have not seen any color of the money. 23 years they've taken a land. So finally now there's a closure. Last time the lordship said that I can't see any award. And it's not my job to find out from record what the award is. From what you have shown me, what the DC has shown me, what you have seen me, there is no award. So he directed the DC, you go look at it again. If there is an award, then you go by the award and old act, subject to land acquisition, new act. And if there is no award, then the new thing. And the DC has said there is no award. And therefore, it's a thing. It's a new compensation as per the new act. Lordship, if it requires, lordship, it's an interpretation, it requires condition, lordship may issue notice, but we must get our monies.
No, that's what we are, even before your argument, that is what I was proposing.
Yes, Your Honor.
That's
But the amount is lordship 22 crores. 22
That
crores.
is the disputed one. The earlier one, my lord will direct, fix the matter on a date, my lord. On that day, my lord will consider and dispose of the matter.
26, just show me that 26. Where is that?
The last page.
It's page 159.
One
59, yes, Your Lordship. Just after
This
the
is the
impugned order.
estimate, my lord, prepared by the deputy commissioner.
It's a consequence of the impugned order.
160.
That's the fundamental dispute is whether it's 30% solatium or 100% solatium. Lordship may keep it in July for final hearing. And in the meanwhile, they should undisputed amount should be paid, the old act amount.
22 crore.
Well,
Yes, Your
that's
Lordship.
the one we are disputing, my lord. If we had to pay that, my lord, we would not have been before.
On what ground?
My lord,
Lordship.
this is the estimate which has been
Page
drawn at page
155.
16, 160, my lord.
Page 155, page at 158. In view of the above, it is decided, page 158, last two paragraphs, Your Lordship. In view of the above, it is decided there was no award as per 11, further, so and so, so and so. Therefore, will be proceeded as per right to fair 2013 to determine compensation. Proposal be prepared by, and this is what it is. And Lordship, now the approval is an easier thing because by notification, the designated the appropriate authority is the DC. So you don't need really further prior sanction. Lordship, the dispute really is whether it's 30% solatium or 100% solatium. So let them pay a 30% solatium the amount.
My lord, that's not the dispute. My dispute is different, my lord,
No, you pay 10 crore, please.
as of date.
Because yes, now she has made out a case. It will go to 20 crore plus.
No, my lord.
It will
The
go.
I'll satisfy your lordship. What my friend is trying to, my lord, project before my lord, is that the order dated 34/2011, my lord, was preceding the section 4 notification. My lord, the estimate was forwarded by the authorities subsequently, my lord, in October.
No,
My lord will have it at page 97.
no, you see, I have understood it now. So far as I have understood, or my view,
Lordship.
not a question of understanding the view taken is, you see, Earlier, that's why when I was referring to 189.90, that was,
That,
that was
that,
struck
my
me.
lord, they had challenged the virus at
No,
that point
no,
of time.
that's okay. But you see, at that point of time when the calculations were made,
Lordship, that's service compensation.
it was only
Service
that and mining,
Lordship,
mining.
lordship.
Then came this, your, what you call, your
Estimate
tripartite
of-
agreement and then estimate. But you see, when in the land acquisition proceeding, she's otherwise right that 30% at least solatium. And those 18% interest and those things will come.
12%, yes, Your Lordship.
So 12% interest, those will be added up. So it will go much, much beyond 10 crore.
With that amount, my lord. Lordship.
It has to go.
Let it come as an order of your lordship. Thank you. Otherwise also 6 crores plus, my lord, interest would.
No, it will go definitely.
Yes,
It will go,
22 crores.
what you call, when it is 2011 and
11,
this
20,
one.
10
So
years. my
it
lord.
will be almost 3 times.
3 times, double.
Three
Double at
times.
least, my lord. Double at least.
So she's otherwise,
There it goes. Minus that 1.5 crores, my lord.
minus 1.5. Okay.
Lordship, they deposit 10 crores. It'll be more than 10 crores, more than,
No, no, my lord.
Yes,
What-
okay.
more than 12 crores.
We'll have
Let
to
me
give-
see some money. They already have my land.
We'll have to keep Mr. Nair also happy.
Lordship, he's been happy for 23 years
No, I just
with,
came in last
with our
year.
land.
No,
I
that
came in
was,
last year only.
that was his instructing council's client.
All right. Lordship, you put that- I can oppose that.
That was the satisfaction of my senior.
Yes, that I can't oppose. Yes. It's not the client, it's, yes. That-
I just take a opportunity to smile, nothing more.
It's required, my lord.
Lordship, my client is crying because his land is gone
No, I understand,
And,
definitely. Yeah, you are right. You are right.
and
That's
he's a
right.
cancer patient, so he needs the money. Lordship, 9 crores, they let them deposit.
That's right.
It's
That's right.
lot more. It's lot more than 9 crores. It's 22 crores on that day plus interest. So 9 crores is a
The
reasonable amount.
ownership, my lord, I don't know. I've
And oil
I've
can
been
afford it, your
instructed that the
lordship.
ownership has changed. The earlier owners who were there, they have
We are
gone.
not bothered with that.
Fine,
We
we are
don't
not
go by the
concerned
names.
about that. Be concerned about that.
Only Mr. Nair was there, so we remembered you. But other than she won't remember. Heard. Mr. U.K. Nair and the senior counsel, assisted by Mr. K. Kalita, counsel for the petitioner. Mr. C.K. Barwa, government advocate appearing for respondent number 1.
No, 4.
Huh?
And 4.
Oh, you'll be for 1. Mrs. G. Hazarika.
1, 2, 3.
Standing counsel for revenue department appearing for respondent numbers
1, 2, and 3.
1, 2, and 3. Mr. C.K. Barwa, government advocate appearing for respondent number 4. Mrs. Hazarika, we have not heard you. You want to say anything?
Sorry.
No. By finding this writ petition in the Article 226 of the Constitution of India, the petitioner has assailed the order dated 13/3/2023 issued by the Deputy Commissioner Tinsukia by the said order it appears that the said order was passed pursuant to order dated, which is that High Court order. This was passed pursuant to order dated.
This was passed, my lord, pursuant to order which my lord would find
15
at page 140, 2/3/23, my lord.
2/3/2023,
Date
passed by this court,
Between 7797/2017.
7797 of 2017,
17.
And
whereby
And there was one more, my lord.
writ petition 6290.
6290 of 2017.
and WBC
6290 of 2017.
6290 of 2017.
Lordship.
First of all. The Deputy Commissioner, Tinsukia, by the said order, held that the proceedings of LA case number 192 of 2011 and 193 of 2011 are not disposed. And that payment as ordered by the Deputy Commissioner Tinsukia was not deposited in the account of the landowners. And accordingly, it was held that the land acquisition proceedings is deemed to have lapsed as per section 24 of the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013. And it was observed that no awards were passed in the said LA case, in the said two LA cases as per section 11 of the Land Acquisition Act, 1984. And accordingly, held that the determination of compensation would be in accordance with the 2013 Act. Next paragraph. Issue notice of motion returnable in 4 weeks. Requisite extra copies of the writ petition be served on a state and departmental council in course of the day. Within 2 days. 2 days. Okay.
Monday.
Next paragraph. Heard both sides on the prayer for interim relief. Next paragraph. It parenthetically appears that the possession of the land was taken for the purpose of no, that is mining here, technical word. Prospecting license, I think. In terms of Rule 189 and 190
Of the rules under the Assam land.
of the rules under the Assam Land and Revenue Regulation, 1886 for under a prospecting license. An effort to determine the land acquisition, the compensation proceedings, sorry, quantum of compensation was negotiated between the parties. But as zonal land valuation was not yet decided, parties agreed that the final compensation would be dependent on the zonal valuation, which would be given retrospective effect. It also appears that subsequently land acquisition proceedings was initiated by issuing a land acquisition notice under section 4 of the, where is that notification? Section 4?
83, page 83.
83.
No, 83 is not not that.
83
is a-
section 4 notification, your lordship, 20th May
No, this is-
2011.
This is not,
86.
Yes, your lordship.
4, yes.
Yeah.
Then
Issued under,
86
under section,
to 16.
under section 4 of the Land Acquisition Act. Did I give a date? Land Acquisition Act it was issued on 25, 2011.
Section 6 is at page 86.
This was followed by section 6 notification, page
Page
86.
86, madam. 17,911.
79, 2011.
August. Right?
While the learned senior counsel for the petitioner disputes that any submits that an award was passed. The same is disputed by Miss G. Goswami. I'm sorry, I forgot. G. Goswami, learned counsel appearing for respondent number 5. by submitting that the compensation, quantum of compensation which was determined was a continuation of the compensation which was to be granted for mining lease, which does not constitute the award under the Land Acquisition Act. Full stop. She has also submitted that pursuant to the Constitution Bench judgment of the Supreme Court of India in the case of Indore Development Authority versus Manohar Lal, 2020, volume 8 SCC 1 to 9. Her case is that the quantum of compensation ought to be calculated under the 2013 Act. Full stop. Next paragraph. Be that as it may, in this case, we find that that the quantum of compensation, as was determined by the Deputy Commissioner Tinsukia, as per the impugned order dated 13/4/2023, no, sorry, as per letter dated 27/4/2023.
27/5.
Five.
27/5.
27/5, I'm sorry, 27/5/2023 is quantified at rupees 22,21, 72,794. Full stop. Moreover, considering that the original award was for an amount of around rupees 6 crore, and the said compensation.
Alleged award, your lordship. It's not an
No, sir.
alleged award.
Okay, alleged award.
My repetition.
No, it's okay, alleged award. Being being calculated on the basis of interest and consolation, would exceed almost twice the amount of the award. The court is of the considered opinion that as an interim measure, the petitioner be directed to deposit a sum of rupees 9 crore in addition to whatever amount that has already been submitted or deposited within a period of 1 month from the date of from today.
Correct.
And on such deposit, the quantum of compensation demanded by letter dated 27/5/2023 by the Collector Tinsukia. Collector cum Deputy Commissioner Tinsukia, by letter dated 27/5/2023 shall not be enforced.
Much obliged.
Next person is in the event, it is provided in the event the Collector cum Deputy Commissioner Tinsukia does not file an affidavit in the matter, he would produce the records relating to
LA case number
LA case
190.
number 192 of 2011 and 193 of 2011, as well as 2 copy of the the award register, comma, if maintained separately.
Lordship.
It's maintained separately, I think.
Yes, your lordship. Should be made it.
If maintained separately. I don't know, I forgot those things. I just know that earlier there were registers, we used to go there, sign and.
There is a register, my lord.
Then
They
we take
enter
it.
it.
But I. 20 years back is a long time to remember.
Because it says it
Or-
should be
or-
filed in the office of the reputable. The wording uses
As
filed in
well
the
as,
office. of the registrar.
including the order of approval, comma, if any, issued by the competent authority in the government of Assam. Next, by this after 4 weeks. I'm not giving a fixed date
Sure.
right now.
Lordship, caveat may be disposed of.
Achha, caveat is there, okay. Caveat discharge, Mrs. Ms. G. Goswami, then counsel for the caveat is discharged.
Not so bad.
Lordship, may I pray for a fixed date, then it shouldn't happen that we get 10 crores and then the matter never comes up.
They can make a mention after 4 weeks. my lord. If required.
20
Oh, my lord, will give a date.
Even
20
August will do.
August
Lordship.
1.
August will be better, 2nd August.
Lordship.
Oblige your lordship.
Item 3.
This is regarding settlement of market, my lord. The welfare by weekly market, and I am the second highest bidder, my lord. Now my bid has been rejected, my lord, because of deficit of 35 rupees of my earnest money, my lord.
You are appealing
My lord, already, my lord, the
For-
lowest
for-
bidder,
for PNRD? This,
not my lord. it is
so this market is settled by whom?
Not settled, my lord. It is already, my lord, they cancel for fresh GMC,
It's already cancelled.
my lord. And already, my lord, the lowest bidder also filed a writ petition, my lord, which is fixed on 23, my lord.
On 23.
My lord.
I think no stay was granted.
No, it says that, my lord, in the meantime, the respondent authority, my lord, extended the, my lord, earlier, the earlier sitting lessee for 1 month, my lord. That has been, my lord, stayed.
Mr. K. Sinha and counsel for the petitioner. Ms. Shruti Alana, standing counsel for.
I'm appearing on behalf of Tina.
Acha, counsel appearing on behalf of Mr. P. Nayak, standing counsel for GMC, representing respondent numbers 2 and 3. And Mr. C.K. Barwar and government advocate appearing for respondent number 1. It is projected in this writ petition that while bidding for the market in question, the petitioner had submitted earnest money, which was 35%, rupees 35, short of the required earnest money. However, the last date of submission of the bids was on 23/3/2023, right?
My lord.
And on the same day, against deficit earnest money of rupees 35, the petitioner submitted a demand draft for rupees 100 to the tendering authority of the Guwahati Municipal Corporation. However, the bid, the otherwise lowest bid of the petitioner was rejected on the ground of deficit earnest money. Next, issue notice of motion returnable in on 23.
My lord, 23/6, my lord.
6/2023. Requisite extra copies of the writ petition we served on the runner state and department council in course of the day. Next, the petition shall take steps for service of notice on respondent number 4 by registered post PWD. The Learned Council for the petitioner has a liberty to collect postal receipt number and submit postal track report prior to the next date of listing. Next, Next, the learned counsel for the petitioner has fairly submitted that in a connected writ petition,
So WPC number 2088,
being WPC
2088.
2088 of 2023, this court by an interim order dated. You have the date?
My lord, yes.
Interim, by an interim order, you don't get the interim order has stated the extension of lease to the previous contractor.
No, that's petitioner, my lord. No, against me, my lord, that has been extended.
Oh,
for
sorry,
one,
again,
because I was the sitting listener.
Okay, against the extension of the bracket to the petitioner. First one. Next, accordingly. Then you write the notice, including notice on the prayer for interim relief. And then you say, list this matter along with WBC 2088 of 2023. Okay.
I have one of your, the name GFM is shown in the cause list for the method of.
Okay. The registry shall reflect the name of GSM in the cause list by listing the matter next.
For
May I please, Your Lordship?
You have saved some money today.
Yes, Your Lordship.
You have saved some money today. We'll list the matter after 10 days to enable you to file an HRA. With
Yes,
that
Your
letter.
Lordship. Yes, Your Lordship.
Why you don't,
Your
you're,
Lordship, that copy is not legible, that's why.
no, but, you see, you're making your case on NHRA and you're not annexed it.
I will find it. Your
Hmm.
Lordship. Your Lordship, in the meantime, that
If I don't see a document, I don't give a stay.
Yes.
You see, yesterday,
because,
till 4 o'clock, I was here. Till 7:30, I was signing all the documents. Went back home. Had to read the file and find out the fault. That the document is not there, and you expect me to give an interim order with all that trouble. It's a wishful thinking.
I'll file by way of additional opinion.
Oh, great. When do you want?
Okay. This coming Wednesday also, Wednesday.
Okay, list on so and so to enable counsel for the petitioner to bring additional document on record by way of an affidavit. Yes, we'll have to issue a direction.
Reporter, let me get the instructions. for
No, no, no. We'll require the authorities to give it because if you are sealing it, where does the police get the power to seal? I'll issue a notice in short date. He may be a worst person in the earth. But you can't-
Report from somewhere else, Lordship, but.
you can't seal it like that. Police won't have the authority. Heard. Mr.
Yes, sir.
S. Learned counsel for the petitioner. And Mr. C.K.S. Bhargava, government advocate appearing for the respondents. The case of the petitioner, and you, whenever you write the petition, you consult a dictionary. It's not a dump, it is a dump, D-U-M-P, not D-A-M-P. D-A-M-P means another thing. You know the meaning of damp?
I mean, that is the shop, Lordship, I mean, but actually, Lordship, what is being, I am.
You read a dictionary,
Yes, Lordship.
damp and dump are two different things. A petitioner projects that he is a owner of a dump cum residence at village Lalon, L-A-L-O-N, Gaon, under Gorchuk police station. Full stop. In or about first week of January 2023, the circle officer, dispute revenue circle, had sealed the said dump in connection with Bhoralmukh PS case number 363 of 2022. by putting up a lock in the door of the premises. The petitioner submitted a representation dated 18/5/2023 before the circle officer, the Dispute Revenue Circle. But nothing happened, and therefore this petition. Next paragraph. Here, under Article 226 of the Constitution of India. Next paragraph. Issue notice of motion returnable on 19/6/2023. Requisite extra copies of the writ petition be served on the learned government advocate in course of the day. Full stop. Next one. As the circle officer, comma, Dispute Revenue Circle, within bracket, respondent number 4, has sealed the premises, comma, the said authority shall ensure that the records
Yes, Lordship.
based on which the premises of the petitioner was sealed in connection with Borolimuk PS case number 363 of 2022, or scanned copy thereof, be produced to the learned government advocate without fail. Full stop. The respondent number 4 shall take notice that on failure to produce records, comma, the court may pass orders on the next date for personal appearance. Next paragraph. The pendency of the writ petition shall not be a bar for the circle officer, Dispute Revenue Circle, within bracket respondent number 4, to deseal the premises, if not otherwise required for any investigation purpose. List on 19/6/2023 in the admission column. The learned government advocate shall, before that you write, the learned government advocate shall transmit a copy of the order to the circle officer by email and or VHF transmission through the concerned police station.
Lordship, some more time than 19, Lordship. Because this,
You see, overnight he can seal it. Within 2 hours, he can produce the records. He has to just travel 2 hours is traveling time from Dispute Revenue Circle to Guwahati High Court.
that is the.
No, why you can seal it?
Is under order of someone, Lordship, Deputy Commissioner.
No. You look at this page. Sealing page is which page? The photograph of the seal. Look at that.
Page 15, 16 is page
Is the one?
16, 16.
Page 16, he says. Just look at that.
I could see only a tala, Lordship, no.
But something is written.
Very much illegible, Lordship.
No, I understand. But he has made a typing. In the front page, he has made the typing.
Under section 379 IPC.
Under 379 IPC,
And in
He-
presence
he
of
is-
Pearl PS
no, it's okay. Under the 397 IPC,
and other order of executive magistrate Dispute Revenue Circle.
no, this way, 379 is what? 379 is theft.
And Lordship, in the seizure list, he have what seized this sharp weapon, Lordship. In the seizure, Lordship,
No, that's okay. I'll tell you. He's a worse person.
one sharp edge screwdriver with black color handle. All
Screw-
over.
No,
And the
screwdriver you'll find in my drawer. Go to my drawer in the, what you call, in my chamber here. You'll find a screwdriver.
And one red color,
Someone else, kindly read.
one red color Activa scooty, Lordship.
No, that scooter is elsewhere. No,
I had thought
no,
it has some
no, it's
connection
okay.
with the.
No, I can understand. He's a worst person on the earth. He's accused of theft.
Listen, I'm only playing for some time, some more time, also, instead of 19.
No. No. He's the worst person on the earth, but can you go and seal these premises like that?
But this under order of the court lordship, it has been done. Under order of the court, no, not court actually, executive magistrate. That part of some. It is not only the circle officer himself, he has come.
Then I will add one more thing. So the Deputy Commissioner, Cooperative Metro Guwahati, within bracket respond number 3, shall also ensure that the records from the executive magistrate dispute revenue circle, where order was passed to seal the premises of the petitioner, or scanned copy thereof be also produced to the government advocate. We get it by 2 o'clock, the order.
Six. In this case, one of the, despite of order.
No, this is something which I'll not promote. You see, in this case, this is item number 6,
Yes, ma'am.
and
10
there's another case,
10, ma'am. Item
10.
Yes.
You see, 2 incidents are happening at 2 different places.
Different.
Same FIR.
No, madam.
Look at it. Serial numbers are same. 7 persons are attacking. Same circumstances. That means it's a setup case. We'll direct the police to make an impartial investigation. It can't happen. One woman is inside the house. Same 7 persons go and assault her. After a few days, another person comes and files an FIR that I was having tea in a tea stall. These 7 persons came and assaulted.
Yes, ma'am.
Can it happen?
Yes, ma'am.
Can it happen?
Yes, that was happened, madam.
It's impossible. It's not. It's impossible. Same male members, same female members will go and attack. All the members, 7 members of the same family will go and attack.
But medical.
And the injury is one cut injury, 2 centimeter into 1 centimeter. Look at it.
Something happened, my lord.
Can't be.
Despite of the order, my lord.
You see, the police understands. That is why it's not doing anything. Even I found it very, very ridiculous. An incident of this would happen. Same people, same set of accused people will go there, keep on attacking one house and another house. Same sort of injury.
No, when you figure this, my lord, the petitioner in item number 6, my lord, the petitioner is the son-in-law of the 100 house, my lord. My lord,
I don't know what has happened, but the same set of same nature of injuries, same nature of 7 people attacking a man with such a simple injury. Page 19 says no sign and symptom. You just get the what you call status of investigation. Have Mr. R.S. Chauhan done it? Counsel for the petitioner and Mr. C.K. Barwa done it. Government advocate appearing for respondent numbers.
2, 3, 1, 2, 3, 4 and 5 also. All the respondents.
For all the respondents. Next paragraph. You should notice a motion returnable in 4 weeks. Requisite extra copies of the writ petition is served on the learned government advocate in course of the day. Next para. The learned government on the instance of listing of the government advocate shall obtain status report of investigation of the of complaint made by the petitioner. What is the case number?
16 of 22.
Not registered.
Huh?
Not registered.
Peter filed a complaint case number.
Complaint is registered.
Investigation of the case which was filed as what was initially filed as complaint case number 16 of 2022 before the Court of Chief Judicial Magistrate Hamren, West Karbi Anglong. Which was forwarded for investigation to the officer in charge, Heroni PS, KHERONI PS, to investigate by order dated 29/9/2022. Next one is provided that no, he lodged an FIR, was not registered.
Yes.
So he went to CGN, filed 156. CGN forwarded, but he says that no case was registered.
Yes.
That is his case. We'll get a status report investigation. Yes, sir. Just after 4 weeks. This an item 10 same.
Yes.
That complaint case is number
15.
15.
Yes.
Same thing.
Oblige.
Second.
In this case, the respondent put their tender. It is
Yes, you have instructions why it was cancelled.
Lordship, the first, I would say the page number, you have to lock the page number 65, your Lordship, an extra D,
10,000 mining.
10,000 cubic meter, 10,000 meter
No,
cube.
no, I understand, but if you have cancelled it, why you give it to a third party to
Because
expect?
it was given under Rule 5, your Lordship. I can take the instruction on that under Rule 5 of the MMC rules, your Lordship.
Mines and minerals concession rules. Assam mine and minerals. No. It will be Assam mine.
Some minor mineral condition rules.
Just tell us, I don't have the book readily.
Yes, Lord.
The requisition book is done. You have a book, please pass it on. Please read slowly.
Yes, Your Lordship. Rule 5 says acquiring of minor minerals by government departments, agencies, contractors engaged by government departments or agencies, Your Lordship. Clause 1 says any application for the grant of mining permit for acquiring of any minor mineral by the notified department of state or central government or any other agencies for any work project shall be made by an officer authorized by the concerned department to the competent authority, Your Lordship. Number 2 says the contractor engaged for the work projects of the government department agency shall be granted mining permit for the required quantity as a specified detailed project report for execution of work projects on making application under sub rule 1 above. So here, Lordship, I will take this at page number 66, Your Lordship. This is a permit, Your Lordship. 66. It says that the forest so in subject is there reference. In reference to the above correspondence, it is hereby to inform you that so and so the work, the contract permit holder has made payment of royalty and mobilized the necessary labor and equipment to start the work. The side work is improvement, upgradation of road from Naharali and under Assam Mala, your lordship. The government scheme, your lordship. So under Rule 5, he was given that work, your lordship, to extract.
No, but first place, why you attended it then? Therefore, you see, can it happen that for every mining lease, supposing, let us say for an example, in the entire state of Assam, you have, say, 15 mining lease. 15. I may be horribly wrong. 15 mining lease. Now there are 100 contractors working all throughout in the state.
It's a lot.
Correct.
Yes.
Now every time a tender comes, somebody will make an application to Rule 5 that you will give me the mining lease. So you give it to him. So these 15 mines which are available, mining lease, that extraction area is there. It will be perennially by the contractors. Then why you need a rule for settling by settling the lease?
Lordship, in this matter, what I was under Rule 5, the government, a government assigns a contractor to extract the material, and the government asks us to give this area to extract the sand for the development work to the contractor. So there's a communication from the government, not from the contractor, lordship. The government asks us that this agency is required, this amount of minerals required for development work. So we need the minerals to be extracted. So kindly give us this area, lordship. It's a government, not a contractor who comes before the authority, lordship. Even before extracting, they has to pay the royalty. The contractor under Rule 5, before extracting, he has to pay the royalty, lordship.
What was your tender amount?
It is a page 21 in SRB.
Page?
21 in SRB.
Yes.
Reserve price 28 lakhs.
Yes.
And lordship, what I want to say that once tender is total, then the withdrawal is illegal.
No, this is only a what you call auction notice.
Yes.
You submitted your bid, no?
Yes, lordship.
How much amount?
Annexure C.
Just tell me the amount.
I have to verify also. It is not readily available here.
Now, in this page 66, Mr. Gogoi, you are showing what is the amount?
The amount here he has paid, your lordship, its total comes to
30,61,200.
yes, lord, 30,61,000.
30,61,000.
Yes, 200.
This is quantity is 12,000.
12,000. In the advertisement, it was 14,000. In the advertisement, it was
No, here I'm on page 66.
Yes.
Quantity is 12,000.
Yes. 12,000 for 33 to 2023. It's for 7 months only. And
So therefore, you are giving it to them at below the what you call tender price. Your tender price is showing quantity is 20,000,
Yes, lord.
and this 28 lakh is for 20,000 cubic meter.
yes,
So 1 cubic meter would be how much? 14,000.
14,000.
14 to 14. How much is the amount? Just calculate. So it will be higher. Is it?
Oh, it's actually. Page 66 is for 12,000 cubic meter.
So for, you see, for 20,000, it is 28,
Yes.
correct? But he's paying for 12, he's paying higher revenue, 30. Apparently he's paying a higher revenue.
Yes.
For 20, it is 28. And for 12, it is 30. Your tender is for 2 years.
Yes.
So it is still higher, in all ways it is higher. This is only a tender for 9 months. But if you notice at this stage then,
If the person has not started extracting the stone yet.
no, but still, the government exchequer is not at loss. So issue a notice, if section 5, they say is a mandatory requirement. At least Mr. Gogoi has an answer. Heard Mr. R. Sharma, then counsel for the petitioner, and Mr. R. Sharma, sorry, R. Gogoi, learned standing counsel for the
Correspondent lordship.
corresponding
Correspondent number
numbers
1,
1 to
2,
4.
3 and 4. Yes.
Next one. The cancellation of the tender for extraction of minor mineral. Which was put to tender. Recast this. By an order dated 28/3/2023, issued by the Divisional Forest Officer, Sivsagar Division within bracket T, the mining permit area which was put for online sale in respect of the DILLI, River Stone Mining Permit Area, capital D, then within bracket Roman 2, capital B, then Roman small 2, for the year 2023-25 was withdrawn. And they said order was put, has been put to challenge this writ petition filed under Article 226 of the Constitution of India. Issue notice of motion, including notice on the prayer for interim relief, returnable in 4 weeks. Requisite extra copies of the writ petition be served on the Department of Counsel in course of the day. First off, the petitioner shall take steps within 2 days for service of notice on corresponding of 5 by registered postal date. A postal receipt, track report. Next, heard both sides on the prayer for interim relief. While the learned counsel for the petitioner asserts that once a mining permit area has been put to auction, the auction could not have been withdrawn, and the lease could not have been given to another contractor for extraction for a period from 30/3/2023 to 30/12/2023. The learned, in this regard, the learned standing counsel for the Forest Department has submitted that as per
Rule 5.
which document we are showing? Rule 5, this 5.
Page 66.
66. So by referring to in this regard, by referring to Annexure E to the petition, it is submitted that the mining area permit was granted to the respondent number 5 under the by invoking the provisions of
Rule 5.
where is that? Rule 5 is not mentioned here.
It's not mentioned here, but it's in the rules of lordship. Then the work, besides the works, improvement, upgradation of road from the Assam, the
28
government scheme, my lordship.
23 it was withdrawn and suddenly on 33 it was given the,
No, because the government wants,
and lordship till today they have not extracted stone from there.
no, it can't be because you see, no, we know that. Because that their plan has to be submitted, ultimately approval has to be given. Was granted under rule 5
Yes, sir, lordship.
of the
Assam minor mineral concession. rules.
Assam Minor Mineral Concession Rules, 2013. Because as per the permit order, the extraction is allowed for improvement and upgradation of road from Nahar, NAHER, ALI, Ali, under Assam ASOM, Mala MALA. Next part. Accordingly, the court is not inclined to give to pass an interim order to restrain the respondent number 5 from carrying out the extraction from the mining area. Next part. However, it is clarified that in the event, however, it is made clear that in the event the respondents do not file their affidavit in opposition on the next date, the concerned DFO, Sivsagar Division shall ensure that the records relating to the cancellation of e-tender notice bearing NIT number capital B/M/1 permit PRNIT /1030 dated 8/2/2023 and issuance of work order, issuance of work permit to the respondent 5 right letter number capital B/MHL/B/M/3 permit 2375-76 dated
33.
33 to 2023.
3/03/2023. This is page 66. And earlier e-auction notice is page 21. The learned standing counsel for the Forest Department shall send a download copy of this order to ensure the production of filing of affidavit and or production of records on the next
Is it
day.
my case is that the government authority once issued tender, they cannot withdraw it.
It's okay, I've recorded that.
Yes, lordship, but
But still it is, if it is,
the impugn order is where then I may be allowed because I am also a contractor.
it's okay, but you see, if the government withdraws it and he says that rule permits it, Let
Rule
me examine
permits to
that.
grant to somebody, but after issuing NIT, they cannot withdraw it.
They have recorded your statement,
there
but
is
I'm
some
still refusing
element.
it.
Because
But I'm still refusing it.
they have also interim till the returnable. It may be made
No.
2 weeks lordship.
No. Once they say that their rule permits it, then we'll have to examine. Just take a break and come back. Item 8. 8. Contractor bill.
Yes, my
Okay.
father.
Okay, journalists. Mr. A.Y. Chaudhary, and counsel for the petitioner. And Mr. C.K.S. Barber, and government advocate appearing for, you are appearing for all the respondents?
No, not for it. He is CEC.
Okay.
It's a central government.
1, 2, and 4. Who CGC who is appearing? You are also a CGC. Okay. 2 you can't appear. CGC given name? Suresh, can you-
Harish Gupta.
Mr. H. Gupta, CEC for respondent number 3. Urging non-payment of of a bill on the present date petition has been filed in Article 226 of the Constitution of India. Non-payment of the bill which was due to the late father of the petitioner. Present date petition filed in Article 226 of the Constitution of India. If you notice a motion, returnable on so and so. Requisite extra copies. Pendency shall not be a bar for the who will examine the
Deputy Commissioner.
the Deputy Commissioner, Hailakandi, when we get respond number 2 to examine the claim of the petitioner and release payment if found due. The petitioner shall produce a certified copy of this order before respond number 2 to bring the order to the notice of the said authority.
9.
The petitioner's 59 acre 4 land for photo number 10 has been made sealing. And thereafter they have filed a petition before the commissioner for review. And the stay order was passed in respect of the land of 59 acres, my lord. Thereafter some illegal activities was done for opening a market site.
Where is the stay order? You said that there is a stay. Where is that?
My lord, it is stays, my lord, as page 23, my lord. It is on the body, my lord, the last body of the petition, my lord.
It's okay. I'm just wanting to look at it.
Yes. My lord, thereafter, the Honorable High Court also passed a stay, my lord. That order is, my lord, page 33, my lord. The relevant page is, my lord, 36, my lord. And the process is going on, my lord. They are making the report, my lord. The circle officer is also furnished report regarding the this review petition, my lord. And now they again.
But Mr. Fugan, I will not be able to follow you. You see, I'm trying to just understand.
My lord.
There is already a ceiling
sir.
surplus case registered, right?
Yes.
Ceiling case has already been registered.
Already registered.
Now you file this page 23 application, which is a review petition. Correct.
My lord.
Page 23 is a review petition filed by you.
Yes, my lord.
Correct.
Yes, my lord.
And now the order passed is call for the report, further proceeding stayed. So you are staying your own proceeding.
No, my lord. The High Court has passed an order, my lord. This is
No, I
page
don't know.
36.
You are showing me page 23. I did not open it. You showed me page 23 and you say that there is a stay order. I'm just trying to understand what is the stay about.
The stay is, my lord, regarding the ceiling.
Can't be. In a review petition, how can a government notification of ceiling surplus can be stayed?
No, my lord. That government has already made stay, my lord, regarding the ceiling surplus. It is already made ceiling surplus. In the review petition, government has passed the order stay of earlier ceiling, my lord, by which the ceiling surplus was made, my lord. That order was stayed, my lord.
Ceiling, when a ceiling surplus case is registered,
Yes.
there's a gazette notification.
Yes, my lord. It is
So you think the deputy commissioner will stay the gazette notification?
no, my lord. Yeah, my lord will find in the page 17, my lord.
Page 17.
Page 17 is the petition before the government, that is before the commissioner. In the matter of the review under section 7(6) of the Assam Fixation of Ceiling Started Holding Act 1956 as amended to that, my lord. And that ceiling case is, my lord, made by the government, my lord. And this review petition is filed under section 7(6), my lord. And thereafter, the ceiling case, my lord, there are two ceiling cases, 700/76 and 741/76. These two ceiling cases were state, my lord.
Okay, then what?
Then, my lord, thereafter, some illegal activities was done for making market set. Then the petitioner filed a representation, my lord. That is application that at 4/1/2017, it is page 29, my lord. Page 29.
Okay,
And then, my lord, as the no action has been taken on this representation, then the petitioner approached before this honorable court, and that is page 33, my lord. And by this order, my lord, the honorable High Court, by order 8/3/2017, my lord, stay is made this way, my lord. It is further provided that till such consideration is given by the commissioner come secretary to the government of Assam in revenue department further construction over any part of the land measuring 59 bighas 2 kata covered by Dag number such and such of pata number 10 at revenue village Azangbari, Panbari, Moja, Kamrup shall not be proceeded with. Thereafter, my lord, this order was followed by the commissioner, and commissioner wrote a letter to the that is, my lord, to the deputy commissioner for filing furnished report, my lord. It is page 41, my lord. the Joint Secretary wrote a letter to the Deputy Commissioner for furnishing report, my lord. Thereafter, it is the letter dated 21st June 2022. Thereafter, the circle officer, my lord, he has received the letter on 26/9/2022, and the process is going on, my lord, regarding the furnishing of report. By this time, my lord, what happens? The government again has started doing some activities over that land, my lord, by making step road, ring well, Anganwadi center, and Pradhan Mantri Awas Yojana, my lord. These are photographs of page 43, my lord. And it is started from page 43, my lord. They have again started some activities, my lord. So that's why this writ petition, my lord, kindly to stop there these activities, my lord.
Yes, Mr. Barua.
Lordship, after reading this 8/3/2017 order of this court, what it says come out, Lordship, that after declaration of the said land being ceiling surplus.
No, no, you see, I'll tell you. I can tell you that you're not following. Yes, you're there appearing in the matter. What do you have to say? I'll tell you why you are not following.
But here, at this stage, my lord,
I'll tell you what is happening.
that's why the review.
No,
has
no,
come.
no. You see the, I'll tell you what is the problem.
Land acquisition. Manual force.
You read this 7/6.
Lordship. Submission of statement to government on the basis of the information given.
No, 7/6. Don't worry about other things. Come to 7/6
Without
directly.
prejudice to any action under any other provision of this act, the state court may on its own motion or application, if filed within a period of 1 year from the date of publication of the final statement under subsection 4.
Yes.
Or, yes,
So now we will stop here. Now the Mr. Fukan says that he applied for there was an order under section 4 of the ceiling surplus.
yes.
And then he approached the government under 7/6.
Right.
Number one, this order of this ceiling surplus was about 2 years prior to his approaching the deputy commissioner.
Okay.
The
here is 1
dates,
year.
the dates are relevant. This ceiling surplus orders were government order dated 8/10/1993, passed in so and communicated to Patadar on 2/3/1996. Correct. So 96 and this this petition is in 98.
Okay.
Therefore,
5
number
years.
one, it is barred by limitation.
Yes, 5 years.
I don't know whether the government has power to extend the period of limitation. That I am not aware. And then there is an order in the page 23 that state. Now, notification under section 4(1) it's not issued by the deputy commissioner to have it stayed. It is by the government. Now, this is one part. The second part is that the earlier, I think I'll require Mr. Talukdar also to explain. Mr. Talukdar, I need you for Panchayat.
I'm for
Oh, cooperative, I'm sorry. For Panchayat, who is there? I'm sorry. Now you see what has happened. Something was going on and he approached this court. This court passed an order of stay. This court passed an order on 8/3/2017. Correct. Here the respondent number 3 is Kamrup Mahanagar Zilla Parishad. Respondent number 3 is Kamrup Zilla Parishad.
Yes.
Now, stop construction order is on Kamrup Mahanagar Zilla Parishad. Now you come to this page 43. 43 is a board. If you read it, you will find very small, but you will read it. It is the work which was done in 2019-20
Yes,
by GP Chandrapur. Sorry, Panikheti Gaon Panchayat.
Lordship.
Now, if it is Gaon Panchayat, if an order is there against the Jila Parishad, will a Gaon Panchayat be bound by it? That is my question. And this, although Mr. Fukan says it's a construction which is now going on, it is already constructed under 14 Finance Commission of 2019-20. The second is a tube well, which is 21-22.
Yes.
Sorry, 17-18. 17-18, and this page 46 is 21-22.
Yes.
So this is not a new construction, it's an old construction. But still, I'm on this, only question is that
Without
injunction,
inclusion of their name. the
no,
construction
against
is-
injunction to a Zilla Parishad, is a Gaon Panchayat bound by it? That is my only question to you.
That PNRD, I think. Started. It PNRD.
So far as this board is concerned, my lord, on page 43, there are the cow concern, as an address, it has been indicated, that probably, not that, my lord, the work has been done by.
Who is doing it? This work will be done by whom?
That of course, my lord,
You see, I can't understand, I will not be able to follow you for a simple reason. The person who is spending money, he will not put his photograph or he will not put his name. That is something which is, doesn't happen,
yes.
because my photo is my motto. Is it not? Any dispute with that legal proposition?
Otherwise, it
any
appears to
dispute-
be addressed, my lord.
No, it's okay, but is there any dispute in that proposition?
No, my
You call PNRD,
lord.
SC PNRD, after some time, Mr. Fukan.
He is appearing.
Oh, you are there? Okay, yes. An injunction issued against the Gaon Panchayat, Zilla Parishad. Will the Gaon Panchayat be bound by it?
That's a will then instructions.
No, you call her, because if I've read so much, I will not postpone it. At 2 o'clock, we'll take it up. You ask by phone,
That's it.
ask her phone,
That's
because the only question is that there's an order not to make construction against the Zilla Parishad. Now the Gaon Panchayat does something. The DA is doing it. Name is given down below. It's being done by DRDA. Page 43, Mr. Gogoi. Name of DRDA is Kamrup Metro. So funds come from DRDA to this Chandrapur block, and the money is spent by the Gaon Panchayat.
And money will come from, my lord, DRD. DRD is under the.
That's what I'm saying. It's a work of DRDA.
Yes.
It will come to the block.
Yeah.
Chandrapur is a block. From block, it will go to GP.
Yeah.
So therefore, my simple question is whether the injunction against Zilla Parishad, the GP is bound or not. That is the simple question I'm asking. Correct.
Probably it will cover, because it's like, my lord, the direction is given to the health department, government in the health department, the director will automatically.
No, its direction is to Zilla Parishad. The director, it is to Zilla Parishad. Had that been there, it would not be a difficult position for me to understand. Page 33, DRDA is not a party here. Gaon Panchayat is not a party here. So therefore, my question is that
Yes.
injunction against 3, whether the DRDA and this are bound by them. That is the only question I'm asking. At 2 o'clock, just call somebody and then ask it. You borrow a copy from Mr. Sikesh Barua. This retribution copy you borrow from Mr. Barua.
Copy.
You borrow it for some time from Mr. Barua. And use it. You have a copy. Okay. Okay. At 2 o'clock.
Man,
Now you get it, Mr. Barba, I said you have not followed it. Yes, next item is item 11,
Lordship, make legal lordship.
unpaid house rent.
Lordship,
Heard. Mr. R. Islam and counsel for the petitioner. And Mr. C.K. Barba and government advocate appearing for the respondents. Next one. The for the child, the CDPO, Baskandi BANSKNDI ICDS project took the petitioner's house on rent. And on account of rent. And on account of rent. Although part payment was made, but the petitioner claims that there is still an unpaid rent of rupees 1,55,160, which has not been paid. So accordingly, we should notice a motion returnable in 4 weeks. Requisite extra copies. Pendency shall not be a bar. For the
Director of
yes.
Women and Child Development.
For the respondent number 2 and 3 to release the outstanding rent to the petitioner. Next, the petitioner shall produce a certified copy of this order before the respondent number 2 to bring the order to the notice of the said authority.
Bless.
12.
this is regarding non-payment of contractual dues.
No. Have you read your brief?
My lord, but
The proposal is not sent.
this proposal is not sent.
So
and,
question of bill will not come.
Notice has to go, Lordship.
Notice has to go. And Mr. P. Bharadwaj, land counsel for the petitioner. And Mr. N. Upadhyay, land standing counsel for the irrigation department, appearing for all the respondents. Next, the petitioner claims that he has done a work of rupees 4,50,000 in 30 days in respect of a work for the year 2021-2022. It is alleged that even the proposal for payment of the bill of the petitioner has not been sent, prepared and sent. Full stop. Instead of notice, should I issue a notice why vigilance should not be asked to inquire? Because officers don't have time.
Lordship, issue notice is just Lordship.
I think vigilance is the best person. They do nothing. Vigilance. Your officers are so busy. You don't have time to make proposals. You do take the work of the contractor. Oh, like 30,000, you do 50,000, you don't pay. Even you don't.
Yes.
Even you don't have time to send a proposal. I think vigilance will do it. They are sitting idle.
2022 matter, Lordship, this is not.
No, I understand. But if you see, if your officers don't make a proposal, I think we'll ask the vigilance to do it. They know accounts.
Lordship, issue notice is just Lordship. Let's see what's comes.
Okay. You should notice a motion returnable in 4 weeks. Requisite extra copies of the writ petition be served on the Runner Department Council in course of the day. Apart by the non-submission of proposal, the initially this court wanted to issue to issue a notice as to why vigilance inquiry should not be made. So how on the earnest on earnest submissions made by the standing counsel for the irrigation department, at this stage such notice is not issued. Next paragraph. Pendency of this writ shall not be a bar for the respondent number.
Sir, 4 matter.
Respondent 4
4.
to examine the grievance of the petitioner and take and do the needful to release the payment of the petitioner, if found due.
Respondent forwards, forward the proposal to the respondent to lordship, which is the process.
Oh, okay, shall examine the matter, send the and ensure that a proposal, if not made, will be submitted, and the same should be inquired and forwarded into the to respondent number 2 for payment, which shall be released if found due.
Obliged.
So I have accepted your request,
Lordship.
but I have mentioned
I'm
in the order.
obliged. I'm obliged.
Yes, Mr. Hazarika, your matter, 13.
Met. 14 shareholder of East Cooperative Society for lordship seeking for a direction to.
Just a moment.
Yes, ma'am.
Question query, page 45. But this default has already occurred as per page 45. If you see the stand of the respondents at page 45 is that once the time period lapses, holding of extended adjourned meeting does not arise. So that is the only point you have to satisfy me.
No, my lord, now that one-man committee has been constituted, section 31(6), my lord, that entails, my lord, that
It will not be a bar for them to stand in the election.
No, my lord, in fact, what has happened?
That is the only thing you wanted to say.
My lord,
That is the only thing you wanted to say.
my lord, by invoking section 41(6), the AGM will be held, will be declared elected because only 15 members they have submitted the nomination. The rule 13A of the Assam Cooperative Society's election rule. It says, my lord, if the members are equal to be nominated, only declaration of results is necessary, my lord. No election will be held. Check rule 13A.
No, that can't be happened. You see, that's why I'm showing you page 45.
My lord.
Stand of the what you call ARCS is that once there's a lapse of the what you call cooperation year,
My lord.
then question of having even an adjourned meeting is not possible.
No, my lord, in
This
fact,
is
what I
not an
understand,
adjourned meeting, my
the
lord.
projected case,
Hmm.
in fact, it is not a case of, my lord, AGM. Lord, what they want to say that under rule 13, if, my lord, the nomination paper is equal to the, my lord, number of seats, then only requirement is to make a declaration by the returning officer that they are elected. Rule 13 appears to be, my lord, such, my lord. If the lordship comes to rule 13, perhaps that is, my lord, this case.
Yes.
No, that is his case. But you see what is happening here. There was a meeting held for that elections. That AGM was held.
Yes.
The AGM on that date could not happen
Yes.
because of lack of quorum.
Well.
So therefore, meeting is adjourned to another date. That adjourned date goes beyond 5
year.
cooperative years.
Yes, yes.
Correct. Now that day goes beyond cooperative year, and therefore your ARCS says that now you can't do anything.
Yes. Correct. My lord, my lord,
My
because
lord,
your lordship will see
my lord,
that
lordship will find the page 54, my lord.
54. Well, that proposition I understand, but that's why I'm only opening up page 45, and that is the only query.
correct.
So what is your stand in this?
My lord, in fact, what I say, there is another requisition pending, that is, my lord, he has stated in 14.
Huh.
It may be taken up together. And I will in the meantime obtain the instruction, my lord, that whether the register, my lord, would allow, because, my lord, rule 13, my lord, has to be read in together with 41(6), my lord. 41(6) says, my lord, the departmental officer will hold the AGM. Now he can hold the AGM.
Yes, ma'am.
And my lord, the returning officer can make a declaration under rule 13. That is also there. So your lordship will take, my lord, both the matters 2171/223 and take up next week, my lord. Para 14 he have stated. In that case, my lord, election has been stayed, my lord.
I'll just understand what you are trying to project. I'll just repeat again. Just tell me if I've wrongly understood.
My lord.
You are trying to say that on the date when the nominations, last date of nominations were there,
My lord.
only 15 nominations had come.
Exactly.
Then you fix a date for AGM.
My lord.
Is it?
Right.
On the date, the quorum was not there, therefore it was adjourned.
Yes.
So you are saying that the 15 nominations which had come was already on record.
My lord.
And therefore, the only requirement is that the declaration of result.
My lord. That is under section 141(6), my lord.
Okay. But what happens? That's why I'm again referring to this page 45.
Correct.
But what happens that before conclusion of that what you call process,
Yes.
the 5 cooperative year lapses.
My lord, 45 is different because 45 says the board cannot do that. I understand your lordship's query. Now board is no more. Because my lord, if by page 54 departmental officer has come in, board my lord goes. Their earlier board is my lord, extinguished, my lord. By 54 departmental officer
No,
comes in.
but Mr. Taludar,
My lord.
you see, I can understand when there is a legislation which says that repeal and saving, this savings clause says that whatever action taken would remain valid.
Right.
But action taken by the erstwhile board, if lapses by 41(6), all the actions taken earlier, is it saved?
No, my lord, 41(6) is different. My lord, this is a gray area which my lord requires lordship's adjudication. Because in number of cases, what I find, my lord, that the AGM is fixed for some or other reason that is deferred, my lord. Here, what I find that has been deferred beyond my lord the period, which could have been done before that, my lord. But for whatever reasons, my lord, that was done after, my lord. Now there is a rule, my lord, holding the field, election rules, my lord. Now the act, my lord, does not, my lord, in a detailed manner, my lord, lay out the procedure. Now your lordship has to essentially read together, my lord, read together. Now this is a gray area which requires your lordship's adjudication. Number of cases are coming, my lord, because this has to be settled. Now under Rule 13, my lord, this is a my lord, interesting case. Under Rule 13, they have acquired some right.
No, you see, the court will have power
Yes.
to read down certain what you call provisions of law. But to add something.
No, here is not, my lord, a case of reading down. If your lordship against come to
No, that's why I'm
41(6).
saying that if it is not reading down, then
Yes.
what would happen is that it's a causes omissions.
Yes.
You're
No, no.
trying to say that.
No, I'm not on that. Your lordship will decide this matter. What is, my lord, under 41(6), where a board fails to arrange for holding election before the expiry of the term of the board or delegates, or where there are no directors remaining on the board. Now board goes, the registrar shall convene a general meeting by appointing an officer of the cooperative department for constitution of the board within 90 days from the date of such appointment, and the officer so appointed shall perform all functions of the board during the said period of 90 days at the cost of the society. Now the departmental officer has come in, the board has gone. So therefore, now the question is, my lord, whether or not 41(6), my lord, will be read with, my lord, Rule 13, and whether the earlier, my lord, members who had acquired some right, this will be, my lord, decided by the honorable court, some right, whether they are entitled or not to constitute the board. Rule 13, my lord, makes it very clear. So this is a gray area which requires adjudication. Otherwise, my lord, this case will come again and again, my lord.
No, but you see, let me be with you in the same page.
My lord, page section 41(6), my lord.
41(6).
My lord.
You see, the reason why I'm saying so
My lord,
is 41(6) only.
my lord.
Where the board fails to arrange for holding an election before the expiry of a term. Now here election was, the process was, election was held before the term.
Yes.
Before the time it was
Yes.
held.
Not this.
Now, after that,
Yeah.
or where there are no directors remaining on the board,
That goes. Earlier director goes.
elected director goes,
They are not before your lordship, my lord.
no, it's okay,
Yes.
it goes.
Yes.
Now, therefore, election held, but the directors go.
Directors go.
Earlier terms, directors go.
Go.
Third, the registrar shall convene a meeting,
General meeting.
general meeting by appointing an officer of the corporation department for constitution of board
There is-
within 90 days from the date of such appointment. And the officer so appointed shall do the function. Therefore, if he is to do the constitution,
Yes.
he can't borrow it from the knowledge from earlier. The earlier act can't be saved because it is his requirement to do it.
Yes, lordship is correct, my lord. What I'm trying to say, that this requires an adjudication. Because under Rule 13, because your lordship will, my lord, read 41(6) along with Rule 13.
No,
Because-
no,
yes.
you see, adjudication is not a problem.
My lord.
But what the question is,
Yeah.
what is the court going to do? is the court reading down the provision, or the court will use its jurisdiction to give a causes omissus, so to add something in the legislature which is not intended.
My lord, in this case, I will, my lord, submit make my submissions after obtaining the instruction, my lord. At this stage, your lordship will pick with the other matter. My lord, this is an interesting case. I will definitely argue in this case, my lord.
It was not interesting. I made it interesting.
My lord, yeah, absolutely, my lord, absolutely, yes, correct. WBC 2171/23, my lord.
Okay, heard.
And my lord, I will say please put 31 up and except 4 minutes. The returning officer is the officer of that cooperation department. He is acting as the returning officer. My lord. Under his control, that the election was initiated. My lord. Even if the early board goes, my lord, the election was under the control of the department. My lord. Page 31 and except 4 minutes.
Let us see what
Yes.
happens. Mr. P. Hazarika, counsel for the petitioner, and Mr. S. K. Taradal, standing counsel for the Corporation Department. The facts, as projected by the counsel for the petitioner, is to the effect that the term of the previous board of directors of
East Badarpur Cooperative.
East Badarpur Cooperative Society Limited had expired on 31/3/2023. Full stop. However, prior to expiry of the term, steps was taken for election of the new board of directors by calling nominations, and it is projected that only 15 nominations were received. Accordingly, an AGM was convened on 5/3/2023 to hold the election of selection.
Election stroke AGM.
Election stroke AGM, okay. So stop. However, on 5/3/2023, the AGM could not be held for want of quorum. And accordingly, the AGM was adjourned to which date?
That is, my lord, page 45, yes.
This was adjourned to which date?
It was adjourned to 12, my lord, I think 12.
12/4/2023.
12/3/23.
As a 12/3/2023. No, you said 31/3 board expires.
My lord, in fact, what has happened,
The AGM was convened.
board
prior to
expired
that-
on 11/3, it was dissolved on 31/3, my lord, by an order.
Oh, I'm sorry, 11.
Not 31/3. It will be
11/3.
11/3. Full stop.
11.
Full stop. Therefore, the Assistant Registrar of Cooperative Societies, Karimganj. By the interim order dated 31/3/2023, held that the earlier that the managing committee of the board of directors of East Badarpur Cooperative Society Limited, Karimganj.
No, my lord, in fact, that is not impugned, that is a letter only, my lord, page
No,
45.
that's an order, page 54.
Page 54, my
It
lord.
is by the Journal Joint Register.
Acha, by zonal joint register, right. Zonal joint register. of cooperative societies which are zoned by an order dated 31/6/2020, held that the managing committee of the board of directors of East Madhya Cooperative Society Limited, Kalimganj, had failed to constitute their new managing committee of the BOD within 11/3/2023, and that the managing committee of the board, the BOD of the said society, stood automatically dissolved. And accordingly, in excess of power under section 41 within bracket C 6 of the 41(6) of the Assam Cooperative Societies Act, 2007, a one-man committee was constituted to manage the affairs and to hold a annual general meeting of the election of the said cooperative society within 90 days. Most of the said order is under challenge in the present petition. Next, the counsel for the petitioners has submitted that as only 15 nominations were received, notwithstanding that the vote stood dissolved, the one-man committee was only required to give its approval to the 15
Return candidate.
return candidates. Next, issue notice, including notice on the prayer for interim relief returnable on which date?
After vacation, well,
No, that petition is when?
that is, my lord, in fact, date not fixed, my lord. It was after 2 weeks. It will come after vacation. So immediately after vacation, July, my lord.
After answering summer vacation,
18th, my lord. 18/7.
the 18th will not fix it. First week we'll have a lot of pressure. 24/7/2023. List along with connected matter being WPC
2171/23.
23. Okay.
My lord, I think the lordship
Obliged, my lord.
take the view that the issue needs to be examined, my lord. Till then, my lord, the election not to be held.
No, I think Mrs. What you call, Mr. Talukdar said that it has been stated there
Yes,
in
yes,
that.
yes. Election is.
Statement, that statement.
Will not be
Once there
held.
is a stay, then.
Yes, no, it will out there. I inform you. Obliged, my lord.
14.
Obliged.
May I please lordship? Lordship, my senior is on like court number 17.
Just a moment.
Kindly pass off the matter for time.
Just a moment. Okay, after some time.
The only thing is that I had lost the caveat. But my copy was not served to me.
Okay, you filed a caveat.
Yeah, we lost the caveat. Caveat number 534 of 2023. I checked the impugn order,
No, but it is not there.
it's not there. We filed earlier. It's not there.
Okay. Both sides are represented at the outset. We just give him a copy of the repression. We'll take it up after I resume, but give a copy to him. After some time. After post lunch, no, after some time is post lunch.
15.
May I please, your lordship?
Yes.
Here the lordship, the petition, right? Here the shareholders of the farming, agricultural farming.
No, you
corporation.
see, it's a misconceived writ petition, Mr. Tamali. You don't even file a representation, you have come here
Lordship,
asking the settlement from the court.
No, lordship, I have filed a representation before the deputy commissioner.
Read that. Read that.
Lordship, to the district agriculture officer on.
Read that.
With
Read.
due respect, it is to inform you that the Jamuna Modanga Krishi Farm Nigam Limited, 90 number Jamuna Mukh LSC under
So
Modanga.
number one, will the agriculture officer give you allotment of land?
No, Lordship. In this
Then-
case, there is a peculiar situation because this,
No, but you see,
Corporation. the land is under the corporation and corporation is now looked after by this agricultural officer.
no,
And
no,
same
that is,
representation was before,
Mr. Tamudi,
Lordship,
Wha-
the
what
same
you-
representation is before the deputy commissioner also. That is at page 59 and XR 5 series.
no, but you have never moved the government for land allotment.
Lordship, here this annexer page 59. To accord permission to accept the revenue from the persons approached agriculture farmer and also to issue permanent settlement of the public residing there. That is there at page 59, last para. Earlier also we have submitted, but we do not have the report, so we could not produce those
So
applications.
this is not a land application, land allotment application.
Lordship,
You see, the advantage of being there, coming from the civil code is that we know what is a kabula, what is all those things. Without that, you won't get a land publication. You just can't come into the high court and say that, well, direct the respondents to allot land to me.
no, Lordship, consider, I have prayed for consideration of my cases because
You see, Mr. Tamudi, for this, I have a very, what you call pet, what you call example. You see, can you ask for the impossible to happen? Consider the representation. What you call, I like this girl. Correct. I like this girl, therefore, direct the respondents to state government to compel the girl to marry me.
no, Lordship, here
No, why? It's what you call, you see, it's a representation. You are submitting a representation to the deputy commissioner. You come to the court that please consider this representation.
because Lordship, we are in a peculiar situation because
No,
the-
no, no, but
the
this is,
corporation
this
is
is,
not, corporation
it's a misconceived
has
petition,
become defunct.
but still,
Then,
without formalities, do you
Lordship,
expect a land allotment to be made?
no, Lordship, then we have approached the deputy commissioner. At least to consider the cases because now, and also the in charge manager of the farm.
Therefore, you see,
Now,
no, let us take it and extend it. Let us extend your argument. After this order, about 10 lakh people in the state of Assam will approach the court saying that, well, direct the respondents to find out a land for me and then allot the land to me. And number two, I am in the land of Mr. Barbhuya is here. I am occupying the land of Mr. Barbhuya. I am giving a representation. Please allot this land to me. I am holding the land of Oil India Limited. Allot the land to me. Can that happen?
no, Lordship, here what happened, these lands are, these are the shareholders of the debt corporation only. That whoever is the petitioner here, they are either shareholders or they are legal heirs. They have,
See, if
they
the
have allotted
companies-
the land
If
already.
the company is, if this cooperative society is defunct, what
But-
will happen is that it will go for a, what you call, under the act, it will go for dissolution.
Lordship, this is not the cooperative society. This is a farming corporation established under the 1973 Act.
You see, what happens if a corporation it becomes defunct? What
Now
happens?
government is allotting some portion of the land to certain persons who were evicted from the landing.
No, this is something which I can't do. I'll still hold it to be misconceived. Without a formal application for allotment of land, I can't direct that X and Y allot the land to them, consider representation of X, representation of Y. I must apply my mind.
And then Lordship, at least they should collect the revenue from us because land revenue which was collected till 2016, that may be allowed. Because that is the manager was collecting the land revenue from us till 2016 it was collected. Thereafter nobody is collecting it.
No, you are giving rent or land revenue.
This is rent, not
So
land revenue.
if a defunct company, how can I direct somebody to accept
Because
rent?
now the company is looked after by this district agriculture officer Hujai. He is the manager in charge now. Because he has submitted the reports of the status reports of the company
and he is the secretary cum manager. In the report that I have annexed at page 73, annexure 7,
73.
page 73 is a report. That is the special officer is the district agricultural officer. Now subdivision, because Hosai has become a subdivision. Lordship may kindly look into page 84. This is the status report submitted on 7/6/2017. This is the district agricultural officer, insert special officer cum secretary cum manager, Jamuna Modonga, Agricultural Farming Corporation, Ambari. He is looking after the corporation.
Mr. Tamadi, I'm still not able to follow you. Come to page 59. This is something you are showing it to us. This is addressed to Deputy Commissioner. And you want me to pass an order against XYZ to
No, Lordship,
receive rent?
this I have submitted to the circle officer also. Then to the district agricultural officer. Page 67 is the same representation I have submitted to the district agricultural officer also.
Where is that?
Page 67.
67.
You are hereby requested to accord permission for accepting the land revenue from the persons residing in the aforesaid agricultural farming corporation, and also to issue patta for the permanent settlement of the public residing there. So second prayer I'm giving up now. At least land revenue or that is rent should be collected.
I still not be able to follow you. You see, under the land and revenue regulation, who is the authority to receive a khajana?
It is the Mozart.
It will be the Mozadar. So you'll have to show us that the government has delegated the power of Mozadar to this secretary cum manager of so-and-so to collect land revenue.
Lordship, the
You see, in
Lordship,
Assamese khajana, what you call the every rent can be said to be a khajana. It's not necessary that khajana would be only the land revenue.
Lordship, may kindly turn to page 54 onwards. These are the receipt of page
No,
53
no.
onwards.
First of all, you see, a khajana can be paid only by a registered, what you call the registered owner. Number one. Second, if somebody else is paying in the land revenue, it will be reflected that so and so on behalf of so and so.
As a tenant.
Lordship, here page 50, Lordship, kindly turn page 53.
53.
These are the land revenue payment receipt.
So
issued
that's
by
what I'm
the-
showing it to you.
Yes, Lordship. These are the receipt issued by the
You see, that's why.
corporation.
No, corporation is there, but the corporation must be authorized to
Yes,
receive it.
Lordship, that is why they are collecting it.
They are correcting it on behalf of the on behalf of the allottees. But this is not a land revenue. Khazana doesn't mean it's a land revenue. For land revenue, you'll have to show us that the power of land revenue was conferred to this authority. You are not the registered patadar of the land.
Lordship,
Khazana can be received at your
Probably.
name.
this has occurred because the English translated copy that I have submitted, I have written it as land revenue on the, that khazana has been
No,
written.
no,
as well.
I'm not finding fault with you, Mr. Tamudi.
Mm.
This is not a finding of fault with you. What I'm trying to ask from you is that if
Yes,
if
Lord,
Khazana is
if
paid,
I'm not a pattadar, I cannot pay the land revenue
you can't pay.
directly, or on my behalf, somebody can
So
pay.
therefore, at best, you can only be a defaulter for not payment of rent.
Yes.
If the company is defunct, you can't be evicted. So if you continue to enjoy that status, you just inform the what you call the person who is now in charge. Who is in charge now?
The district agricultural officer,
District agriculture officer.
Hujai.
Officer that you have given him. You give him an offer and then sit tight. So otherwise, you see, since I come from the very odd place, which is a civil bar, I can only say that you deposit rent in court. Well, this is something which I can't do anything more.
Yes.
Your rent is due, you pay rent in the court at best. But we can't do anything. That agriculture, what you call this, land allotment is a business of the government. Unless you file a kabula, it's accepted when sent to the land advisory committee.
Yes.
There can't be a order of the court to consider representation.
And now this land, this is in the name of the corporation, entire land was.
No, whatever be, but that there is a system for land.
The government has allotted some land, some portion of it to some person. So our rights has come under, because we trade, because we could not pay the land revenue also.
Those arguments won't take me anywhere, because of the fact that once that is done, they're under the 163 of the land revenue rules under land revenue regulation. You have to move the state government in appeal. Sorry, Board of Revenue in appeal
Yes.
against the order of allotment.
Order of Deputy Commissioner.
Deputy Commissioner first, then Board of Revenue against.
Here-
No, so then against. After that, the state government. So that is the procedure.
But here we are allotted the shares and we are given the land under a special act.
No, I'll pass orders after time because there's a full court meeting right now. I have to leave. Because I'll close this repetition. But give you liberty if you so want to deposit rent in court at best.
Yes, Lordship, that can-
Asim Tamuli for the petitioner, CKS Barwa. Government Deputy for respondent numbers.
Responding for question. 4, 4, 5. 468.
468, Mrs. Hazarika, you are for?
Number 1.
1, you are for?
2 and 3.
Lordship, not 6, not 8, Lordship, not 8. Not 8, 4 and 6 only.
Only 4 and 6.
6.
Sure.
3, 5.
Additional Deputy Commissioner Hojai.
Lordship, it should have been serial respond number
It's
4,
okay,
capital
it's
A.
okay. That's why I'm saying.
No, there are actually 2, 4. That's why.
No, we'll omit those things. Minor things are there. You will be appealing for the Deputy Commissioner,
Then
Additional Deputy
additional, yes,
Commissioner,
yes.
2 of them,
2 of them. And 6.
and last
What's the
9
sum?
also.
9
Circle
also, yes,
officers. You just correct the seriatim,
Yes, Lord.
because in the next page also you will find difficulty.
I'll make
at
it
the-
4A
yes.
capital A.
Yes.
I'll make it 4 capital A, additional Deputy Commissioner Hojai. I'll make it 4 capital A and
Yes, okay. At the outset, the land counsel for the petitioner submits that there is incorrect marking of serial number of the respondents. Accordingly, he is permitted to renumber the second serial number 4 as serial number 4A. Next paragraph. Now you write for him, he'll be, Mr. Barwa will be appearing for 4A. And 9. District Agriculture will be appearing. You are appearing. Your name I forgot. R. Bora. National Council for Agriculture Department appearing for respondent numbers 2, 3,
6.
5, 2, 3, 5, 6, and 7.
Yes.
And Ms. G. Hazarika, standing us for revenue department, appearing for response number 1. This, I will continue to. I'll continue to because I have to rush. It's a full court meeting.
Lordship, if you lordship permit, may I leave?
Yes, please. It's okay. I've recorded your presence, no problem. I'll only give you liberty to deposit when in court
Yes.
and remove the government if you want land allotment.
Yes.
Only these two things. It's in business. Be permitted to remove their bodies.
I have seen my caveat, probably this is defective. Maybe,
Just wait a minute.
because just mention only order dated so and so, no memo number. In the particular. So. Maybe, because that's why it is not shown in the computer. But since it is issued by him, that's why I'm pointing out the parallels. That is the particular. There is no mention about memo number. Maybe that is the reason it is not been recorded. But it is my duty to point out on the chat.
It's okay. Just check it out. Filing section will be local. It will register Jagadish Rajvanshi.
Oh, all right, my lord, take it on Monday, my lord.
No, just 1 minute. It'll take me 1 minute.
My lord,
Just by the next time I take, it will be
my
gone.
lord,
Because if it is there in the registry, then you will know it.
my lord.
Just give me 5 minutes time. In the
And
meantime, I
tried
take up
to
another
contact-
matter.
He tried to contact the person whose name was there, his telephone number, it was ringing, my lord, he has not been picked up.
It's okay. After some time, 17.
May it please your lordship, non-payment of contextual.
Oh, acha. Okay. Mr. P. Bordele, counsel for the petitioner, Mr. C.K.S. Babar, and Government Advocate appearing for all the respondents. Non-payment of contracted bills. Penalty shall not be waived. Extra copies.
Obliged.
18,
Might be lordship, man. That might have municipality, your lordship order is page 92 and 93 of the that information without the sending the matter to the governor, my lord. That they on their own, they have included and they have notified. And your lordship was pleased to call for the records and affidavit. In the meantime, till 23, my lord, fix it is. Page 93.
Okay, same compensate.
Same.
But,
No, not same. Government is different.
Government is different. Okay.
Actually, my lord, your, it is Kupkana Gao Panchayat, it will be one of Uttar Krishnapur Gao Panchayat.
Oh, okay.
In the synopsis first line.
In this case, notice of motion was not issued.
No. Today it has come from motion.
No. In the earlier page, this page 93 order,
Yes, in that case, notice was issued.
notice was issued.
Yeah.
Okay. Because after I signed this order,
Yes,
it came to my mind
my lord.
that if you are selling the inclusion of an area in the municipality, then I think a public notice is also required to be issued. Otherwise, at your instance,
No, they have issued, my lord, they asked for objection. And the majority of the people had objection, my lord.
no, I understand. But still, there has to be a newspaper publication of this notice.
That's not good.
Otherwise, in your petition, it will be an ex parte order without hearing the stakeholders. That you came to my mind, but
Oh,
since that order was not passed in the open court, I did not add that. You get my point.
so I got your point. Your
because-
question is, my lord, initial draft notification they have made.
No, that is okay, but
Yes.
now when we are adjudicating the matter,
Yes.
the public has a right to
Certainly,
make it say,
either way.
Huh.
Other side of the mess say that yes, we are ready to.
ready to be there.
Right.
So we're
Your
directing a notice to be published in the newspaper.
That's so.
Of inclusion.
That for the interest of all but maybe some person they may not.
Yes, somebody may
support also.
contest your writ petition. Heard. Mr. H.R. Chaudhary, Learned Senior Counsel, assisted by Mr. H.I. Chaudhary, Counsel for the petitioners. Also have Mr. C.K. Barol and Government Advocate appearing for respondent number 1 to 4.
Municipality.
My lord, I'm appearing for 5 and 6 on behalf of Mr. S. Datta.
Okay. As well as Miss, your name?
S. Musahari, my lord.
S. Musahari, Learned Counsel, appearing on
6.
behalf of
6.
Mr. S. Datta, Senior Counsel, for respondent numbers 6 and 7.
No, my lord.
No,
Response
7 will be Gao
5 and
Panchayat.
6.
Panchayat.
Oh, Panchayat. Panchayat will be appearing for
5
Panchayat.
and 6 is sits on municipal courts.
Chief Executive Officer, my government official.
And Panchayat will be.
Oh, 5 and 6. Okay, 5 and 6. She will be
7 is
appearing for
Panchayat.
5 and 6. 7, you will be appearing.
No, Panchayat.
Panchayat.
PNRD.
PNRD, Mr. S. Datta.
This is without dip now.
Mr. S. Datta, Standing Counsel for PNRD Department, appearing for respondent number 7. Agreed by the decision of the authorities to include certain areas covered by Krishnapur,
Uttar Krishnapur.
Uttar Krishnapur Gaon Panchayat into the
Ward number 1, 2, 3, and 5 to be included as ward number 41 in the municipal corporation.
ward number.
Ward number 41 in the ward number 1, 2, 3, and 5 of the Gao Panchayat
Of this Uttar Krishnapur Gaon Panchayat
proposed to be included
Is proposed-
as ward number 41 of proposed Silchar municipal corporation.
and accordingly the said decision has been assailed by the petitioners by filing this writ petition under Article 226 of the Constitution of India by projecting that certain benefits which would have accrued to the petitioners being precedents under Gaon Panchayat would be lost. Issue notice including notice and declare for interim relief returnable on when
That is other case 23-6 it is fixed point. Other case.
23/6 same day 23/6/2023. Next paragraph. Requisite extra copies of the writ petition will be served on the United State and Departmental Council within 2 days. Next paragraph. As public interest would be affected. The court proposes that it would be appropriate. The court is of the considered opinion that it would be appropriate that the petitioners publish a notice in one English and one Bengali daily, having wide circulation in the area.
That Bengali paper will do my lord. English normally I don't think is there.
But still 2 papers are required. To the public in general to show cause as to whether they have any objection in the prayer made in this writ petition. First of the draft of the notice shall be routed to the registry of the court and upon newspaper publication to be made at least to be made within
That state date of returnable will be,
I think return date has to be extended then.
yes.
Make it returnable on 19/7. Publication to be made within six, 7/2023. Upon service, an affidavit of service shall be filed prior to the next date of listing. List on. Date, 19. 1906.
97
97, 97.
in the meantime. In the meantime.
Huh?
In the meantime. 393.
Okay, to the next date of listing, it is provided that the impure notification dated, where is that?
28/11 September
28/11/2022.
Page 83.
Okay. Published in the Assam Gazette Extraordinary on 30/11/2022. Issued by the notification dated 28, so issued by Commissioner Secretary to the Government of Assam, Department of Housing and Urban Affairs, which is published in the Assam Gazette Extraordinary on 30/11/2022, shall not be acted upon.
Obliged.
$59.
Mr. Barba, same thing here also. You'll have to obtain instructions as to whether it was placed before the governor or not. Just make a note in that. This will be required again. Item 59.
That the registration of our pharmacies has been cancelled.
Oh, achha, that day
Yes,
we had the matter.
Lordship, we do have received the instructions, but right now I think it is best that Council B. Gogoi place it. He's on legs and court number 5, Lordship.
After
If
some time?
possible, can we take? Yes, Lordship, that is. Lordship, Lordship.
60. Yes, ma'am. But the
Yes.
petitioners are in possession of a particular plot of land for last
Just
70
a
years.
moment. Similar
60.
similar matter came about 10 days or 2 weeks ago.
That is, my lord, for settlement, my lord. It is, my lord, here, my lord, notice. Kindly see page 56, my lord. And it's a ref. Notice has been given, my lord, to the petitioner without giving any opportunity of hearing, my lord. To vacate the land, my lord.
What is it paid in the earlier rate petition?
That is for settlement also. Praying for settlement, right there. So, my lord, the petitioner.
No, just a moment.
Petitions are from SC schedule caste community.
No, in this rate petition where you refer to the earlier rate petition, I did not get it.
My lord, it is there.
Where? I did not get it.
So, my lord, this page 39. Page 39.
No, you moved similar petition with 10 days or 2 weeks ago.
Yes,
It is for the same petitioner.
same petitioner for settlement only.
No, then you'll have to disclose the earlier rate petition. Why you have come earlier in the rate court?
Already notice to vacate the land by lord.
That is different, but you must come with clean hands. If you have filed an earlier rate petition, you have to refer it here.
That's his new cause of action. is
Mr.
arising.
Chauhan, every day what happened 2 weeks back or 3 weeks back, I don't remember.
Yes, that's there.
But in this case, there was something which triggered my memory, and I could recollect that before about 2 weeks ago, I heard a similar matter.
Yes, that's
Correct.
yes.
It is your duty to disclose it, otherwise
Yes,
I'll
yes.
dismiss it for what you call for incorrect disclosure for. No. You are the lawyer. Why you should remember it? If as a judge I can remember that I have dealt with the matter 2 weeks back, you will remember it more. But if you suppress facts, I'll be dismissing your writ petition.
No, my lord, kindly, my lord, the petitioner have their family members.
I
school
don't care.
children-
I don't
children, my
care.
lord,
Why should I care?
And my lord, old age in
Why,
mother, my lord.
why should I care for someone who has not come in court with clean hands? You don't make a disclosure. There can't be 10
My lord,
writ petitions.
that person may be taken up with this petition, my lord, along with 3076, my lord.
List this matter. Whenever WPC
0676.
3076 or 2023 is listed.
And in the meantime, for some protection.
No, absolutely no.
My lord,
You amend your writ petition, you do whatever you want. If you want me to pass an interim order or issue a notice, then you'll
my
have
lord,
to come
in the
with this.
meantime, my lord, they may be.
Let him be evicted right now. I would not care because you did not disclose material facts. As simple as that. You can just
My
record.
lord, kindly allow, my
Mr.
lord, kindly, I may be.
You amend your writ petition, you file an amended copy. But in this manner, I won't do it. Why should I, what you call, put my brain to stress? Mr. Chauhan, if I put myself to stress, I would become ill in 10 days. You expect a judge to remember what has happened in the courtroom 10 days ago, 22 months ago, 1 month ago, and then be prepared for it. It was your duty to come with clean hands.
That is there, my lord. But-
No. The court refuses to entertain this writ petition
My lord, I'll
because.
amend. I
So
may
do
be
it.
allowed to amend.
Then say. As the previous writ petition filed by the petitioner is not disclosed in this writ petition. The learned counsel of the petitioner. Is granted permission. To amend the writ petition. Which shall be done. By. Setting out. The amended portion. And file it before the registry to be tagged with the record. Post of thereafter matter may be listed in the motion column.
My lord, till then some protection, otherwise they may be evicted, my lord, any moment. My lord, they are school go children, old ailing mother is there, my lord.
I told you, Mr. Chauhan,
Yes, but that is there, my lord, but
I told you, I can't do it and I will not do it. It will encourage wrong statements to be brought.
some.
No, then you see, you made me withdraw the earlier order. My earlier order stands that the court refuses to entertain the writ petition because of suppression of material facts regarding.
Yes,
Just add that refuses to entertain the writ petition at the present form because of suppression of material fact relating to previous writ petition of the petitioner in this court. I'm not doing it. There's something I won't do.
well, considering this fact of the case, my lord. Should be, my lord,
I can't do it. And I will not do it.
my lord, they
You-
will come to the state, my lord, on the state, my lord.
No, you have a right to go to writ appeal. You are not remediless. Are you
My lord, in the
remediless?
meantime, tomorrow or today.
I will not encourage. If it is a wrong disclosure, I am not encouraging. Even if you keep repeating this till 4:30, I'll be very happy to entertain only your application because then I don't have to hear anyone else. But this is something I won't do. I would not encourage a writ petition without material facts being stated.
Well, then liberty, my lord,
I know.
liberty.
Liberty I have granted, but you insisted on the prayer, I added more.
Item number 9.
But you'll have to amend it. In fact, I'll just address the bar. some issues have cropped up because of this. A lot of matters are coming up for correction of orders where the cost title is wrongly made. I'm just addressing the bar generally. Many matters are coming up where the cost title is wrong. So therefore, in the order, the cost title of the rate petitions are taken up from the CIS system, where incorrect orders are reflected. As incorrect cost title is reflected, and now under the CIS system, unless we amend the central registry, this will continue. So therefore, now we are moving towards slowly towards the e-filing mode. So therefore, corrections by hand, if done in a rate petition, will not be reflected in the CIS system.
Yes.
And it will not be available to the learned council. So we are now doing a changeover where correction by hand will no longer be permitted. This what you call this sheets will have to be filed in the registry so that it can be tagged and the CIS system can be updated. This is the process. Otherwise, some issues have cropped up in some matters. Yes, Mr. Chetia Fukan. This is item number 9. You got an information?
That's it. Video informed me that the petitioner gave a representation before the video on 18/11/22. But earlier they do not receive any order copy.
Okay. Okay, heard. Mr. DCC Fukan, the counsel for the petitioner. This year's article, for revenue, you will be there. Oh, Miss PR Mantha, Mrs. PR Mantha, and then standing counsel for the revenue department appearing for respondent number 1. PWD, Mr. B. Goway, I'm standing counsel for PWD appearing for respondent number 2. Panchayat Rural Development, you will be there. Miss
N. Bora.
Miss N. Bora, then standing counsel for Panchayat and Rural Development Department appearing for respondent number 3
and 9.
Social welfare, you government. Mr. CKS Barwal and a government advocate appearing for respondent number 4
or 6.
6, 8. Now, PHE, Mr. R. Gogoi, standing counsel for PHE appearing for respondent number 5. In construction of certain public beneficial projects on the land of the petitioner has been agreed by construction being made. Regarding public of the community welfare schemes on the land of the petitioner. The present petition is filed under Article 226 of the Constitution of India. Issue notice including notice on the prayer for interim relief, returnable in 4 weeks. Requisite extra copies of the petition be served on the learned state and departmental council within 2 days. Next, the petitioner shall take steps for service of notice and respond by 10. By 10, you can't do anything. You'll have to amend your petition. You can't issue a notice like this. President and secretary. This is a wrong, incorrect cost title.
Well, president secretary is there in the Panchayat.
In one notice, I'll give to president and secretary, and then they will take the paper, divide in 2, and then read it.
No, my lord, I will do the secretary separately.
Next, insofar as the cost title for respondent 10 is concerned, the same is found defective as in the same cost title, the president and secretary have both been referred to. First of therefore, the petitioner shall amend the cost title in respect of respondent number 10 by including by bifurcating them into two separate respondents, and an amended cost title shall be filed by the petitioner before the registry of the court to be incorporated in the in this petition, subject to the amendment being brought in. I should notice on the amended to the respondent numbers 10 and proposed respondent number 11.
My lord, if permitted, I can make it by hand, my lord.
I just said right now, that's why I spent 5 minutes time.
My lord,
We are no longer permitting it
my lord.
because the CI system, there's we have received what do you call objections, because the people who are watching from outside, they don't find these people in the website. So it's causing some problem, administrative problem with us. And I know it because I'm in the ICT, so therefore I am the first person to receive all these complaints. What is the construction which is now going on? I have not found anything. Where is?
My lord, para 7 is there, my lord. Para 7, page 10, my lord.
Mr. Chetia Fukan,
My lord.
do you want me to record that false statement is being made in the writ petition? You want me to record that? You see, look at these photographs.
My lord.
All these photographs have year. One photograph is of 1920, one photograph is of 2122, one photograph is of what do you call 1920, one is 1718, and you are saying that construction is still going on.
My lord, this 22 photograph is there, my lord.
Today we are in 22.
20,
I'll be so glad.
2020.
My superannuation age will be deferred by 1 year.
My lord, 46. 46 space, 46 is.
I have seen everything.
My lord.
So you want to say that we are now living in 2122. I'll be glad. You just have to make a statement. I'll record that statement and make the declaration.
My lord.
Mr. Banik is so happy. He's down by 2 years.
After
I
passing
also
on
see
the
a
order,
smile.
my lord.
I also see a smile on Mr. Das sitting behind. In the laughter. No injunction. No injunction. All these constructions are long back. It's completed. We are behind time.
14.
And you have heard her. He says that earlier certified copy you never gave it to her. Video says it. The certified copy is never received. He is
No,
not
no,
given
there
it.
was not party there, my lord.
So therefore, if they were not parties, you get an injunction in 2017. How will it help you?
No, my lord, government was party, my lord. There. All the government officials.
I don't know. I can only say, but I can't convince you.
This
I can
High
only.
Court order, my lord.
I can only say I cannot convince you. Yes, Mr. Barbuya, you are at item 14.
Yes, my lord.
But I have not the
My lord,
keep it,
interim maybe. Maybe.
I have not the keep it in the matter.
Item 14.
Item 14. That has not been tagged, possibly some error was there.
It's okay. You have avoided the copy.
No.
No.
Is not the party, my lord. Here, my lord, the case is as simple as it is, my lord. There is
No,
a, my
just a
lord,
moment. If he's filed a caveat,
534.
but he is
I
not
filed
the
on
party.
2nd of June. Repetition was filed on the 7th of June, registered on the 14th of June. Possibly some error somewhere, possibly.
give him a copy.
Also, my lord, he is not a party also there.
No, they have not arrayed me as a party. I
My
have
lord,
lodged a
they are
caveat.
not necessary party also. Lordship will kindly
No,
help with the subject matter of the case.
No,
my
no.
lord.
You see, the principle of caveat is that one who apprehends application against a particular order may come to this court. You, whether you implead him a party or not, that is not the principle of caveat. Principle of caveat is that once who feels that he is aggrieved by that a particular order is under challenge. It is not that he apprehends that he may be a party in a case. It's not that. Caveat doesn't say that.
My lord, that is true, my lord. But here, my lord, I am not seeking relief against individual
It's
party.
okay, but it depends on what is presented and how Mr.
My lord, in
Manik
my
has
most
a-
respectful submission, regardless of the merits of the matter, if I have lodged a caveat, by virtue of that, I am entitled to be heard.
Yeah, entitled to be heard.
To be heard in the matter. That's a different issue, necessary party, proper party. That's while arraying a party or impleading.
But you have to give him a copy once he's a caveator. His caveat is on 2nd. We'll have to accept it, what Mr. Banik is saying.
I can pass over a copy of.
But just wait. You see, in this case, Mr. Bagmia,
Lordship.
I'm not issuing an order of stay. Because what I find is I saw a document where it says that it is within eco-sensitive zone.
No, my lord, that is. the
Once if it
wrong
is, no,
term
no,
by-
it may be false.
Yes,
For that, we'll prosecute the officer for making a false remark. But this Dibru fishery number 1, if it falls within the eco zone, then we'll require those notifications to be brought on record. Not without that. Till then, I'm not passing an order of stay. It's an eco-sensitive zone.
my lord.
Yesterday, yes, please.
I'll clarify the point, my lord. Yeah, what happened, my lord? The border of my fishery has been redefined. That has been notified by sitting a commission.
Oh, whatever be
Lordship.
that. But once it is eco zone, whether it has been,
No, my lord,
the
this
borders
is
have been shifted.
Directed, my lord, not a court directed
I have seen those things.
to go for the press tender, my lord.
It can't happen. It will be contrary to the judgment of the Supreme Court of India.
My lord, in pursuance
My
to
lord,
the notification of the central government. Then, my
against
lord,
the
a
same
committee
cause
was
of
set up.
action.
Committee was set up comprising of 11 members. Thereafter, my lord, again committee was set up by 5 numbers of persons.
So that I don't know.
complex-
Once you see, even a passing remark comes that it is eco-sensitive zone, I will
It
require
is
the
the
ministry,
outside, my lord.
I will require the Ministry of what you call environment to step in and give us the information. Once it is eco-sensitive zone, then then it's my duty under the orders of the Supreme Court,
It is the
that
outside the,
inquiry must be made.
my lord, I'll just satisfy on to that point, my lord. It is the outside the purview of the eco-sensitive zone, my lord. And in the meantime, my lord, to clarify that stand, my lord, I'll file additional affidavit and I'll submit copy, my lord, may come up on Wednesday. I'll come with the central notification.
No, once an area is declared as a eco-sensitive zone, that what I understand is, with my limited research, is that the coordinates are also mentioned in the notifications of the Ministry of Environment
Yes,
under the Forest Protection Act,
yes,
Environment Protection Act.
yes,
These coordinates are given. So whether the boundary is X or Y,
my lord.
we are not at all concerned.
It is the outside.
So
Anyway, my lord,
uh,
I'll file the additional affidavit, bringing my lord central notification as desired by your lordship, as well as my lord, I'll sub the extra copy, we come up on for motion on Wednesday or Friday.
done Wednesday. Wednesday.
And my lord, I'll file the affidavit, my lord, bringing.
I will permit you. Will permit you.
Lordship.
At the outset, Mr. S. Banik Learning Council submits that on behalf of Mr. On behalf of,
David Bolwer.
huh?
David Bolwer. The caveator.
What is the name?
David Bolwer.
David Barwa.
David Bolwer.
David Barwa. A caveat has been filed against the order dated
23/5/23.
23/5/2023, which is impugned in this writ petition. And accordingly, therefore, he submits that the caveat was filed on 2/6/2023, and this writ petition was filed on 7/6/2023. First of accepting the submissions made by the Land Council, the Mr. J. Barhunia, Land Council for the petition, shall provide a copy of the writ petition to the learned council appearing for the caveator.
Today itself.
Though he is not a party in this, though he is not arrayed as a party in this writ petition. Next part, the Mr. J. Barhunia and counsel for the petitioner. Place for is granted. Time to file additional affidavit to bring on record additional documents on which he intends to rely on. Next para. As Mr. R. Govil and standing counsel for Forest Department.
This one is 4, 5, and 7.
4, 5, and 7. Mr. D.
1, 2, 3, and 6.
My lord,
I'm just recording the presence.
my lord, instead of Wednesday, my lord, be fixed on Friday, my lord, so that I.
It's okay, whenever you want.
Yes.
No difficulty with that. Correspondent number, you have for fishery department?
No, not my lord, as a additional senior government.
Acha, okay. Additional senior government advocate appears for respondent number 1,
2, 3,
2, 3,
6, and 8.
6, and 8. We make it Friday. Not
23.
23. Listing the motion column. On so and so. But I'll need that clarification on this what do you call eco-sensitive zone.
28/1/2020.
I got my lord.
The Central Ministry has issued a notification whereby the Blue
No, on that day, no, on that day, please be prepared because
Yes, I'm-
uh,
Even
File my lord.
a monitoring committee has been formed, constituted. DFO is a member secretary. The deputy commissioner is a member. The 15 members are there. They are to do under the Environment Protection Act of 1986. That's the law.
no, I understand, but I'm not equipped with much of the law.
I'll bring my lord the central notification 28 January 2020.
Preliminary things I knew, I said. Beyond that, I don't know.
I'll bring it to the record.
All right.
Huh? Oh, that Mr. Mohanto, that caveat is there. That caveat is there. We'll take it out Monday then.
Monday, showing real name because you try to
Okay.
contact me, what will I?
No,
do?
it's
Then
okay.
not
Oh,
pick up.
okay. No, it's okay. It's okay.
Showing the name, whose person name get there,
Huh.
Monday.
At the outset, item 16, at the outset, Mr. T.J. Mohanto, Learned Senior Counsel, assisted by Mr. B. Islam, counsel for the petitioner, has fairly submitted that his instructing counsel has received a copy of caveat by post. And although several attempts were made to contact Mr. Nurul Haq, advocate for the caveator, at his mobile number 910-1619-392, but he did not pick up the phone. First off, the registry is informed that the caveat is lodged under serial under number. The caveat is registered as caveat number 379 of 2023 registered on 26/4/2023. Just accordingly, raise this matter in the motion column on Monday. Monday will be 19. The registry shall also tag the caveat number 379 of 2023 along with this while letting this this writ petition. Okay, I'm sending you back. Monday.
59.
Yes,
On last occasion, Lordship has directed me to have instruction
yes.
as to whether, my lord, that personal hearing has been given or not. I would like to place the document, my lord.
59.
It is dated 29/4/2019. And they appeared, my lord, Lordship will be the last page. There is the acknowledgement. In the third page, my lord,
Yes.
there is the acknowledgement. So they appeared, they submitted and they presented everything, my lord. Thereafter, my lord, as per direction of this honorable court, we have issued a final support. And we have terminated them, being not satisfied with their reply. So my humble prayer, my lord, there is a statutory provision for appeal before the
Mr.
government.
Sharma, you are aware of this?
My lord, I'm furnishing it.
Give me a copy.
Lord, these dates are already fixed by the honorable division bench. As per that, we have submitted and they have given an acknowledgement. That's also I have enclosed that. But they have to give an opportunity as per the mandate of the Pharmacy Act, my lord. The personal hearings should be given before
So
taking.
he
any
is saying that
steps.
you are heard.
I will not hurt, my lord, because these are the date has been fixed by the honorable court itself to appear and submit the documents,
Where is the High Court order?
my lord. Is on 256, my lord, first. Starts from 238, 246. Already we come to 249. Insert 248, 5. Roman 5,
Yeah, just now.
my lord.
Roman 6, my lord.
Yeah, just now.
My lord.
246. Yes, which page you said?
249.
49.
249.
Roman 6. On that day, they appeared, my lord. They presented their documents before the authority to justify their, my lord, stand that they are, my lord, genuine and bona fide pharmacists. And thereafter, my lord,
Where is the impugn order?
yes. Page, my lord, 296.
No, this has to be interfered with.
Well,
Appeal can't be, they can't be rejected the appeal. Absolutely nothing. No application of mine.
well,
Otherwise, my lord, I am also giving that alternate prayer as stated as, because after cancellation, then I have the option of moving to the state government for filing appeal. Well, lordship stay the imping order, I will move before the appellate, they will scrutinize whatever. I do.
Till then,
My lord,
don't implement this.
so far as this petitioners are concerned, about, my lord, more than 100 have been now with.
No, I understand, but if this is the order,
My lord,
this is not sustainable. Absolutely nothing in this order.
any
but
imping
my lord,
order,
that liberty may be given to the petitioner to approach the authority for
Yes.
appeal. But my lord, without making any observation in the merit, lordship may
Yes, I'm not
yes,
getting.
keep it in abeyance. Yes, in the meantime, they can approach.
my lord.
Heard Mr. S. Sharma, Learned Counsel for the petitioners. And Mr. B. Govil, Learned Standing Counsel for all the respondents.
My lord, all the response.
For the respondents, Standing Counsel for Health Department appearing for all the respondents. Next paragraph. The pharmacy licenses of the what do you call, what is it called? The registration of the petitioners as members of the Assam Pharmacy Council. Has been cancelled and their names have been, and the names of the petitioners have been removed from the register of Assam Pharmacy Council
My lord,
by impugned order dated,
29/4/2023.
which is that,
My lord, it's 296 onwards, up to 310.
oh, okay.
96.
On 29/4, on various dates,
Various days.
on various dates between 29/4/2023 and
04.
15/5/2023.
There are four dates, my lord, I'll give that. There are 4 dates,
Sorry, you write and give it, okay.
I'll give.
There are 4 dates, huh? And accordingly, the said orders are under challenge in this writ petition filed in the Article 226 of the Constitution of India, amongst others, on a ground that an opportunity of hearing as required under Section 36 within bracket capital I of the Pharmacy Act, 1948,
My lord,
was not afforded to the petitioners. At the outset, the learned Mr. B. Govind and also the learned standing also for the health department has submitted that under the Pharmacy Act, 1948, there is a provision for an appeal to be filed before the State Pharmacy Council,
No, state government, madam.
before the state government
State government.
against the decision taken by the Assam Pharmacy Council of removal the names of persons from their role. Under section
36(4).
36 within bracket 4 of the Pharmacy Act. Next one. The learned counsel for the petitioner suggests that he would avail the said remedy. However, it is submitted that as the impugn orders do not reflect that an opportunity was granted to the petitioners of being personally heard. Now it is prayed that for some time the impugn orders may not be given effect to, as it would amount to loss of livelihood of the petitioners. Next paragraph. Although the prayer made by the learned counsel to the petitioners has been objected to by the learned standing counsel for the health department, but as the impugn orders do not reflect that an opportunity of hearing was afforded to the petitioner's farmer. The court is inclined to keep in abeyance the hearing before referred. Orders dated 15/5/2023 issued by the Registrar Council Secretary, Assam Pharmacy Council. By which names of the petitioners were removed from the register of the Assam Pharmacy Council for a period of 15 days from today, within which time the petitioners shall file the appeal as per the provisions of section 36 within bracket 4 of the Pharmacy Act 1948. Next paragraph. It is clarified that the interim order is only to facilitate the petitioners to prefer an appeal, and it would not prejudice any side because the order has been passed without adjudicating the correctness of the or the order or the impugned orders. And on consideration that the livelihood of the petitioners may be immediately affected, may be adversely affected. First of all, with the first observations.
One more thing, subsection 3 of section 36, it says that an order under subsection 1, that is the order of cancellation, shall be subject to confirmation by the state council and shall not take effect until the expiry of 3 months from the date of such confirmation. Even if the confirmation is made on May also, 3 months they will get the time, it will not be given effect. That is a prescribed provision in the rules. Otherwise also.
Imping order reflects the state council has given the confirmation on 20th January 2023.
Then also 3.
After 3 months, they will. So the interim order, my lord, kindly see the.
No, it's okay. I'm doing it, but I'm recording a statement.
Yes, yes.
My lord.
296.
No, I'm not withdrawing my order,
My lord.
but I'm just adding what is saying. Just in this statement you add, Mr. Govind written that by referring to the further comma, by referring to section 36 within brackets 3, it is submitted that the orders impugned in this writ petition would not be given effect to till expiry of 3 months from the date of making of such order, as such orders are required to be approved by the state pharmacy council.
State council.
State council, okay.
Yes.
Page 296, subject to correction, my lord. They have already given that in the bottom. State council has confirmed on 20th January 2023.
In that case, of course, 3 months is over.
296, my lord.
No, just show me the Pharmacy Act.
My lord.
It was.
Well, it seems well, a 3 months period is over because January confirmation was given.
But then I have to pass an elaborate order.
Well,
You see, then I have to pass an elaborate order.
My lord.
Mr. Sharma is right.
My lord.
You see, this says, one says, subject to the provisions of this section, the executive committee may order that the name of a registered pharmacist shall be removed from the register after giving reasons so and
My
so.
lord.
Correct. Now, this order of removal of register, removal of the pharmacist from the register is passed on 29/4/2023.
My lord.
Before passing of the order, this section 3 says an order under subsection 1 shall be subject to confirmation by the council.
My lord.
Now here what is happening? You are removing him from roles on 29/4
My lord.
and the council is approving on 20 January 23
Yes.
before the decision approval.
My lord.
But then I'll have to take it on merit and then I have to touch on merit. I can't do it. What I was doing was wrong. You remove him on roll on 29/4. Approval is granted pre-decision. That means this decision itself is a bad decision.
no, my lord, lordship will see, my lord, executive committee's resolution.
Number
70
6, so and so, and confirmation by state council under section 36(3).
Yes.
It couldn't have been done. I'll have to go into the merit. I'll have to issue it.
No,
I
lordship-
can't relegate him to appeal.
No, lordship may, in that case, my lord, may I have a look at the rules again. 17/8/2022.
Cannot do it. I'll have to issue it. Set is a tie. Order will be subject to confirmation. It's like a death sentence. Correct? A death sentence must be confirmed by the division bench of this court. Now, what happens if the division bench of this court gives a confirmation of the death sentence and the what you call the trial court convicts him and gives him sentence after that? It can't happen. I'll have to interfere.
In that case, lordship will give us an opportunity to file affidavit, my lord.
Yes, definitely.
That will be.
Then I have to stay it. I have to go on merit.
Lordship.
Then has been challenged. We have said that so and so was challenged this petition. Issue a notice of motion returnable. Just right.
My lord.
His statement also right. Mr. Govil, so and so and so. Next paragraph. issue notice of motion return over in 4 weeks. Requisite extra copies of the writ petition be served on the runner departmental counsel within 2 days. Next para. Heard both sides on the prayer for interim relief. Full stop. In this case, the grievance of the petitioners is that pursuant to the order of this court in WPC
3438,
348,
3438,
oh, so 3438
my lord, oblique 15,
oblique 2015. Just give the date also.
my lord,
Date of the order is
31/5.
31/5/2018, filed with this court in so and so, and connected cases, comma, the and other connected cases,
My lord.
comma. The petitioners were granted opportunity to submit their documents and then to documents on the dates mentioned in the order. And according to the petitioners, submitted their documents concerning documents to substantiate their eligibility to remain registered in the role of pharmacist under the Pharmacy Act 1948. Full stop. On a reading of the impugn orders, it does not appear that any opportunity of personal hearing was granted to the petitioners, which is found to be contrary to the statutory provisions of section 31 within bracket 1.
36 one.
36 within bracket 1. Is 1 or it is I?
36 1 sub I, 36 1 sub I.
So it is 36(1), subsection 1.
36 within bracket 1. Not I, 1. Of the Pharmacy Act. Full stop. Moreover, it is noted that although the impugn orders of removal of the names of the petitioners as pharmacists under the Pharmacy Act were passed on various dates like 29/4/2023, 5/5/2023, 9/5/2023, and 15/5/2023, the state council, even prior to the decision of removal of roll, passes an order on 21/2023, confirming the removal. And in the impugn orders, it is mentioned that the confirmation by the State Council under section 36 within bracket 3 of the Pharmacy Act 1948 was granted on 21/2023. Therefore, full stop. Next paragraph. The provisions of section 36 within 3 of the Pharmacy Act is quoted below. Next, from the above, it appears that it was a premeditated decision by the State Council to remove the petitioners from roll, for which it gave confirmation even prior to the date on which the Assam Pharmacy Council has passed an order of removal of the petitioners from the roll of pharmacist. Next paragraph. Therefore, the availability of alternative and efficacious remedy of appeal would not dissuade this court from entertaining this writ petition, as the issue raised in this writ petition goes to the touches upon the illegal manner in which the name of the petitioners have been removed from the role of pharmacist. Next paragraph. According to command list on list after 4 weeks. Accordingly, the operation of the interim orders dated so and so under various serial numbers for 4 days shall remain state until the next date of this bill.
My lord, 5 days, I will give that.
Give that.
My lord.
Otherwise, there will be mistake in the order.
My lord, obliged.
Also in this matter,
Just a moment. Yes,
have received this from the circle officer also. Fundamentally, it has come from DCP also. Also, it is a well speaking order. Later action.
you can have this. We'll take it after some time. Under the CRPC, where does the you see the when it is a deputy commissioner, sorry, deputy commissioner of police, he has got ministerial powers. You are aware of it, I think. That is why commissioners were created, because he has ministerial powers. Now, to invoke such power, he must refer to some source of power. Like you see, when a deputy commissioner or a deputy commissioner imposes 144, what does he do? He says that I so and so, under the provisions of under powers conferred under section 144, impose what you call prohibition under 144. If he does an action under 133, he says so.
Yes.
There is one more power for the district magistrate to the collector to handle. I forgot. Now, where is the power to seal the premises? You see,
This dump is a part of investigation.
no, it's okay. It's okay. You may seize the goods, but to seal the premises because of theft. I'll just give an example. It may be inappropriate, but it's still an example.
And because it is.
I'll tell you, Mr. Sharma Bhava. You see, now let us assume that a very costly pen you left behind today. You left behind in this courtroom a very costly pen. Correct. Now you give an FIR that I have perhaps my pen was stolen in the High Court premises. And then this police comes and seals the High Court. It's an extension of what is being done here.
Also, there is a presumption that that seems to be a storehouse of stolen material.
It's okay. I don't disbelieve you. For a moment, I'm not disbelieving you. I'm not questioning you. But I'm just asking you to take this book and find out where is the power of sealing. Source of power has to be there. And this goods, this scooter which was stolen was not recovered from that place. Mr. Samabhava, if you are practical, you will understand. You see why 2 motorcycles are stolen in the city. You are aware of it. One is Pulsar, is the highest the vehicles which are stolen. Number 1 is Pulsar. Number 2 is
Scorpio.
No. Bullet. Are you aware of it?
Yes, sir.
Where it is used? Why it is stolen?
for using the engine actually for
Where?
motor Bangladesh.
for motorboats, right? So therefore, you see, every police knows it. But they don't, they've never sealed the entire, what you call, applying of Butbutis on the, what you call, river Brahmaputra. Sealing can't be done like that. You can seize the articles, you found a stolen article, seize that, take it away. But can you seal my house? Somebody will come do, what you call, very easily, what you call, throw a, what you call, a sandal in my house. And then tomorrow I get my house sealed up just because a sandal was found, which X claims to be his. It can happen to any small incident. I have given an example of your costly pen. You have lost it here. But can this lead to closure of this? No, I don't think so. I'll just add this in that order. In this order, I'll just add this part. But there will be some delay in giving you the order. After I rise only, I can give that correction. I'll record that your deputy commissioner's order was there. This is the order. Munna taken it, huh? Just add there. Add. Here, huh? At this juncture, the learned government advocate has produced a copy of order under memo number DCP/WGPD/C/ this number you take it from here, dated 31/12/2022, by which the Deputy Commissioner of Police, West Guwahati Police District, had requested to detail one executive magistrate, had requested the Deputy Commissioner, Kamrup Metro Guwahati, to depute a magistrate for sealing of the dump of the petitioner, as he was of the, as the said authority was of the view that the dump seemed to be a storehouse of stolen material. Full stop. Therefore, the court is inclined to direct the Deputy Commissioner of Police, West Guwahati Police District, Guwahati, to produce the relevant records, which has led him to pass an order of sealing the dump of the petitioner, and he shall also apprise the court the source of power which has been invoked for having the dump of the petitioner sealed. Financial reparation shall not be barred for the competent authorities, including the Deputy Commissioner of including the Deputy Commissioner of Police, West Guwahati Police District, or the respondent number 4, and oblique or any other authority to de-seal. That is continued here in the next page. Same order. We continue here. Okay. The instruction produced are made a part of the record.
Not next date is fixed on 19 lordship.
Okay, we'll make it 20, this 20. Okay, I understand.
Production is item number 1.
Yes,
Your lordship, the respondent number 9 had availed a loan from Assam because
just one. Yes,
your lordship, the respondent number 9 had availed a loan from Assam Gramin Vikas Bank, which your lordship will find at page 41. And for availing that loan, he had given security equitable mortgage of his land, the details of which are there in page 41 in the sanction letter. Just may I read the relevant part?
not required.
Your lordship, then ultimately the respondent number 9 defaulted in payment of his loan, for which the bank was constrained to file the OA before the DRT Guwahati. And there also the description of the equitable mortgage property has been given in the schedule as well as a body of petition. And ultimately the DRT by order dated, which your lordship will find at page 64, 24 to 21, had allowed the OA and also directed that the mortgage be kept alive till it is realized, if the amount is realized. And the equitable mortgage property described in the order also is similar to the petition as well as the second loan. Thereafter, there was attachment being proclaimed, and accordingly the DRT, which your lordship will find at page 66, directed that eviction notice be issued to the certificate debtors. And respondent number 9 is the borrower of the statement. Now, what has happened on the 12/6/23, while the bank official with the assistant of police went to evict the certificate debtors, that is the borrower here, respondent number 9, had also tried to take in possession of my land, the petitioner's land, which is not part of the description of the property in the order of the DRT nor the mortgage property. I own a land of 2 kathas 10 lectures wherein the dark number is 619, and one of the dark number of the respondent number 9 is 620. So while trying to date, somehow I was able to stop the bank official and the police, but they have threatened that they will be coming on the Saturday, that is tomorrow, to take possession of my land. So that would be in a very illegally manner. I'll be disposed of. I am still in possession of the land, and I have given the Jamabandi to show that that land belongs to me.
Where is the entry?
Your lordship, place of the Smith version starts at page 35 and 37 is at just the third entry that shows how I got the land.
Page
37, your lordship.
37.
Yes.
Yes.
See, third entry, your lordship. Sitha Sokravikoy Mahadev, 13/3/2009, Igrazi Tari Hukum Mote, Korida Putra A Potta, 619. Dagor, Ek Biga, Ek Kotha, Terolesa, Zomin, Pottadar, Atao, Mukutor Sthanot, Onisur Zaman. Onisur Zaman is the petition. There are two lines been described here. That's why it has come as 1 Biga, 1 Kotha. That is 619 and 620. And your lordship, at page 38, would be clarified how much 619 has.
Where is your sale deed?
Sale deed, your lordship, is a positive. This I have given a statement. I have not annexed it here. But your lordship will find it.
What is the statement date? What is the date of the sale deed?
Your lordship, just before that, page 38, if I can take your lordship, page 38.
Yes.
Just the second last entry. 169 number Pottar, 619 number Dagor. The on Dui Kotha 10 lesser. That is Dui Kotha 10 lesser. That is a description of 619. In the
Mhm.
previous place, it was shown together 619 and 620. Here it clarifies how much 619 carries. So I'm only I'm only claiming protection in respect of 619, that is 2 kotha 10 lesser.
You see, the difficulty is another. Here, the land.
This was anyway, your lordship,
No,
agricultural
no.
land.
Not that. What is the area of land you are referring to? First entry you showed where page
Page
37.
37.
37. What is the land area?
1 biga ek kotha 13 lesser.
Yes, and the second entry at 38.
Is 2 kotha 10 lesser.
There are only 2 entries.
Yes,
In this doc for 619, there are only 2 entries.
yes. I want to show that the 619 pertains to 2 kotha 10 lesser. I'm only claiming in respect of that. In the last Zomi,
Just a minute. So there must be some more land in the dark. There has to be some more land in the dark.
yes, but I'm only now seeking protection for 2 kothas 10 lessers, which is mine. Because this land evidently belongs to the petitioner Onishur Zaman. In fact, 620 is also agricultural land, but that is respondent number is 9. But I am only seeking protection for 619. And the bank official has ought to have carried out demarcation by the allotment before taking the possession.
What is the pata number?
Pata number is same, 169.
169.
Yes, sir.
Okay, heard. Mr. R. Sharma, Learned Counsel for the petitioner. And you are appearing for
My lord, issue number 4, 5, 6, and 7. My lord, on my humble submission, my lord, there is a dispute between the bank and the petitioner. And the bank is going to take over the land as per my submission of the petitioner. That though they did not mortgage the land, the mortgage was given by the proforma, my lord, respondent
no,
here,
that is not his case.
my lord.
Case of Mr. Sharma is that the land which was offered for mortgage is a land covered by DAG number 804.
My lord.
Separate DAGs were 608, 277, 620, 587. And therefore, petitioner is a owner of land in DAG number 619. 619 was never mortgaged.
My lord.
So you see, if a land is a mortgage land and there is a dispute, then under the Recovery Act, the what do you call, the DRT will have power
My lord.
to adjudicate.
Right.
Because now even fraud and all, by virtue of Supreme Court judgment, all powers have been confirmed with regard to dispute of possession. Everything the DRT can do. But if the land itself is not a mortgage land, then perhaps the tribunal will not have jurisdiction.
My lord, tribunal has, my lord, as the projected case of the petitioner, tribunal has not directed to, my lord, take over land of the petitioner.
But
Their case is that,
yes,
but wrongly bank, my
it's
lord.
not bank, it will be deputy commissioner which is doing it.
No, my lord, that they did not say so, my lord.
You see, that's what I'm saying. That's what
They
I
did
have
not say
examined.
so, and they did not even made any complaint that
No, no.
our land, though it is not a mortgage land.
The bank does not take over any land without the assistance of land revenue staff.
My lord. They are
And
saying,
I can say so because I had personal experience in handling these matters at one point of time. Therefore, you see, a bank will write to the deputy commissioner, and the deputy commissioner will depute officer of the assistant settlement officer, or what you call the lot mandal, to visit the site, have the what you call demarcation done,
my lord.
and then only they take it over, and the handing over is done by
Exactly,
the
my lord, exactly
land-
your
land
lordship
acquisition
saying
staff.
so, my lord, this is the case. My lord, but case of the petitioner, pleaded case of the petitioner is that they are not saying that deputy commissioner, circle officer, etc. They are saying that with the help of the police authority, they are taking.
Correct. You see, what will you do, Mr. Sharma?
My lord.
If, let us say, you are a decree holder,
Right.
correct? You are wanting to evict the other Mr. Sharma,
Right.
correct? Then what will the court record? Who is evicting? Who is putting the decree to execution? It will be Mr. Dharmendra Sharma against Mr. R. Sharma. Will the court write that the decree is being executed by the deputy commissioner? No. So if the land revenue staff are going, is going because of you.
If, my lord, the land of the petitioner is going to be, my lord, evicted, they are evicted, my lord, without the, my lord, a decree from the my lord.
So can I record your statement that in the case they are evicted without due process of law through the land revenue staff, the state is ready and willing to pay compensation? Can I record that?
My lord, undoubtedly, my lord, their land cannot
No,
be
I
taken up,
understand,
my lord,
but supposing it is done,
my lord.
will the state pay compensation to the petitioner?
My lord,
If you say so, we'll protect the state.
my submission is something else, my lord,
No, I understand your submission, but that is my question.
my lord,
You're right in making a submission, but it's my question which I'm posing.
my lord.
You see, I have power under section 165 to put questions which are relevant or irrelevant. You know that? The court has a power to ask irrelevant questions.
Yes.
If you have any doubts, I will give it to you. That is why I put so many irrelevant questions. 165. This is something I take pleasure in reading. And by now I'm trying to, what is it called? Memorize it, but I can't.
But what I would like to submit before your lordship, my lord, if, my lord, they are going.
You see, the state must protect the lives and property of a citizen.
My
It is a fundamental duty.
Yes, my lord.
Can you say that this fundamental duty are not performed because the bank has given us to acquire the land? Can you say that? Then you see, 165. Court may ask any question, relevant or irrelevant.
Yes, my lord.
Correct.
Yes.
Therefore, I always, in course of my proceedings, I always ask in a day a irrelevant question. And you'll have to excuse me for that.
My lord, I'm not saying so much. In fact, my
No,
lord,
we'll say
without
609.
perusal of this, my lord, my submission was not that. Only I would like to
No,
protect my
I
lord.
just-
My lord, before going to making any complaint before the deputy commissioner or circle officer, he had preferred the state petition directly. My lord, perhaps, my lord, if my lord, some complaint has been made before the deputy commissioner, that aspect has been looked into. That was my submission, my lord.
Okay. Was R. Sharma, this is D. Sharma, an additional senior government advocate appearing for the state respondent numbers. 1,
My lord, 4, 5, 6, and 7.
4, 5, 6, and 7. Yes,
And my lord,
KPR
one, two, and
Monto,
three.
Standing Council for Revenue and Disaster Management Department, appearing for respondent numbers 1, 2, and 3. Next paragraph. By referring to the sanction letter of term loan of rupees 50 lakh granted to a particular borrower, namely Mr. Faizul Faizur Rahman RAHMAN, dated 8/6/2013, it is projected that in order to avail loan, the said borrower offered page 41 from page 41, tick mark. Full stop. It is projected that the said borrower failed in repayment of the said loan and interest and to service interest on time, and accordingly the Assam Gramin Vikas Bank, Ramdia RAMDIA branch had approached the debt recovery tribunal under section for recovery of the said loan, which was registered as OA number 104 of 2020. Reference is also made to the schedule of the land. Appended to the said OA, which is as follows, page 61. Full stop. It is submitted that in the that the said OA was allowed by order dated 24/2/2021, where the claim of the bank was kept alive on mortgage properties, which is already described here in above. Just a copy of the part of the order where the land is described is annexed as Annexure 4 to this petition. Full stop. Next, by the counsel for the petitioner possesses that on which date?
12/6/2020.
12/6/2023, the bank, the officials of the Gramin Vikas Bank, along with land revenue staff, had measured the land of the petitioner, which is 2 Kata 10 Lecha and covered by dag number 619 within bracket now 619 capital A of KP Pata number 169 within bracket new under Hajo Revenue Circle. Under village Dehar Kuria, DEHAR KURIHA under Moza Ramdia RAMDIA under Hajo Revenue Circle, which was also measured by the land revenue staff. And it is projected that on the said date, the petitioner could somehow save his land, but the authorities, but he is expecting that the land revenue authorities along with the bank officials, would come to his land on tomorrow. Tomorrow, 17/6/2023, and take over the said land by evicting the petitioner. Next paragraph. Hence, this replacement under Article 226 of the Constitution of India. Next, the Illinois government advocate has submitted that he is unable to accept that when the land of the petitioner is in bag number 619, the land revenue staff would take over possession of the land of the petitioner, which is covered by bag number 619, and is not the mortgage property. Next, with the resume, issue notice of motion returnable in notice of motion include notice and prayer for interim brief returnable on so and so. Next, as the court finds that in the order of the State Security Tribunal, Guwahati, dated 24/2/2021, passed in OA 104 of 2020, the mortgage land, the description of mortgage land does not include any land covered by the Act number 619. Of village Dehar Kuria under Randia Moja, the court is inclined to restrain the Deputy Commissioner Kamrup Metro Kamrup Amin within the respondent of Circle Officer, the other revenue circle. Will make a respondent of 5 from dispossessing the petitioner from any part of the land which is covered by the Act number 619 of Pata number. The same Pata number village, Momoza and everything. Till the next date of listing. Next. Before that, issue notice returnable on so. Extra copies of the application be served on the State and Department of Council for respondent numbers 1 to 7. Petitioner shall take steps for service of notice on respondent numbers 8 and 9 by registered post with AD. The petitioner shall also serve notice on respondent number 8 by Dusty mode by routing the process to the registry of the court, and upon service and affidavit of service shall be filed. Then this interim order. Just after, give a fixed date. No, give a fixed date after 4 weeks.
24/7.
24/7. The petitioner shall produce order of this, a certified copy of this order before the circle officer. Hajo. What is that? Hajo?
Hajo Revenue Circle.
Hajo Revenue Circle. So bring the order to the notice of the said authority.
My lord, once again, although my lord, order has been dictated, I would like to, my lord, point out one line from the petition, my lord.
Yes.
Paragraph, my lord, 9, page 16. It is not the case, my lord, Land Revenue Authority are going to evict. My lord, their allegation against the bank without demarcating the land, without, my lord, going to the required process, the bank authority is going to evict. It is to be stated that authorities, especially the Assam Gramin Vikas Bank, ought to have got the land demarcated by the Lat Mandal or revenue authorities before taking possession of the land mortgaged by the pro forma defendant. The Assam Gramin Vikas Bank, with the assistance of the police, has already taken possession of some portion of the land mortgaged by the pro forma defendant without carrying any process of demarcation of the land by the Lat Mandal or revenue authority as evict from the photographs. Nowhere they have mentioned that the land revenue authority or deputy commissioner is going to evict the land. It has not been pleaded in the information. Only allegation against the Assam Gramin Vikas Bank.
Okay, that we can, you have not made the allegation against land revenue staff.
Your lordship, these are villagers cultivators.
No, this is okay, but
Yeah,
here you have not made a statement.
That's it.
No, you see, why do people come to a lawyer? They don't come to a lawyer because the lawyer is an agriculturist.
Because the lordship, they couldn't.
The clients may be an agriculturist, but they come to a good lawyer.
They didn't know whether they are deceased.
No, that is okay, but in this petition, it's not mentioned. So we can't make, Mr. Sharma is right. We can't make a statement against the petitioner if it is not stated in this. So that this instead of land revenue staff, we make it that the government Vikas Bank, the Randia branch, or its officials shall not evict. Yeah, right.
'61 to '63.
This is a bail matter. This is a bail matter. Is the APP present? Just give us call for APP. APP item number. 46.
'61 to '63.
Yes, I think this will take some time. There's one more request made for upgradation.
My lord,
Apart from that, I may not take up any matter.
personal appearance was there, item number 26.
Yes, we'll take it up. Personal appearance is there, then we'll take it up.
My lord,
Just wait. Personal appearance will take it up first.
we have filed the affidavit, my lord. And as per lordship's, my lord, we have already sent that fee notification, my lord, on 12/1/2013, my lord. Lordship will look into, my lord, annexure fee page 68 of our affidavit.
Page.
Annexure fee page 68.
$58. Highway.
68.
68.
My lord, we have sent that fee notification on 12/6/2023, my lord. And the petitioner's plot of land at serial number page 69, serial number 6, my lord.
Okay, so
We have already corrected, my lord, 65 PP3, and it is commercial.
Yes,
We have
okay,
already
but-
sent it, my lord.
but that is after this order.
Yes, your lordship.
After this
Online.
order. Okay.
My lord, as there is a, my lord, joint verification is required to
Yes,
be
okay.
carried out, my lord.
Once it is done,
My lord.
I'll not take a adverse.
My lord.
uh,
And it is now the NHA initial, it will send to the central government for publication, my lord. And there is nothing surprise, my lord, in this situation.
I have a simple pair, your lordship. As per page number 45, your lordship, in the main read petition. Earlier, they have stated that the total land will be acquired as 0.1097. And this order was sent by the Kala, that is response number 3, to the general manager NHIGCL. So this report was submitted after verification of my land, your lordship. Now they have again stated that no, re-verified, and they have stated no, I am going to take your land area, that is.
My lord, there was a joint verification after that, my lord. We have issued notice to the petitioner also.
Let me hear, then I'll understand.
Yes, your lordship.
Yes. Now,
Now in the affidavit, your lordship, they have against changed their version. They have stated that no, we are not going to take the total area of land, that is 0.1097. We are going to take 0.0381.
okay.
So your lordship, we are in a fear that again they will change their version. like that.
We all live with fear in our lives, is it not? I step out of the of this enclosure of High Court.
Yes, sir.
What will happen in the next moment, I don't know. I can just walk out. That is my liberty. What would happen on the road is not my, I can't do anything. You may have apprehensions, but we can't help it. Now they are reducing your land.
Yes, your lordship.
So you should be happy. Your friends in the bar, they deserve a treat. You have saved some land. Is it not? Huh?
My lord, lordship will look into para 13 and 14 of our affidavit. My lord, as part of my lord National Highway Act, my lord, joint
No,
verification.
I know that. Those things
We asked the petitioner to be present for joint verification. We have asked him to be present. My lord, she was not present. And the joint verification was made with the NSA Judicial Authority. And we have annexed the joint verification report also, my lord.
It's okay. We're not going to that.
My lord, page 67 is the joint verification report also. NSA Judicial signed it, my lord, on 10/1/2023. At the joint verification, she was not present at that time.
It's okay.
At the time she was in Delhi, your lordship.
It's okay. For some
Yes,
reason
yes.
you are not there. It's okay.
Yes, your lordship.
So now they've issued that, what do you call?
3A notification, my
Three
lord, for
notification.
publication, my lord.
Where is that?
Annexure 3, page 68.
68. This notification is yet to come.
And the notification will be published by the NSA central
okay,
government, my lord.
that's
We
okay.
have sent it on the
That's
my lord
okay.
draft.
So your grievance is addressed.
My lord.
Okay, heard. You are the Joint Secretary Revenue Department. You have noticed what has happened. Just because of the delay, what unfortunate remarks we have to make. People are losing their land. Please try to understand. People are losing their land, and they are asking for compensation, and you don't send this to the appropriate authority. So therefore, presumptions are raised against your what you call it, against your actions. And this has led to us to give a notice that why your inefficiency should not be recorded by the court and sent to the Secretary for insertion in your ACR. If you have a public duty to perform, you will have to do it. Correct. Please make him understand that
My lord.
it's something which can't be tolerated.
There is some delays there, my lord,
So-
after the joint
No,
verification.
but
also.
people are losing their land.
My lord, my lord.
The-
Land has not
the-
yet been taken over, my lord.
The land
Now,
has not been taken, they can't do anything, they can't enjoy the land. And the authorities who are wanting to, were required to do the work, don't do it. And in the meanwhile, the cost, supposing the land, the road cost was 1 lakh rupees, will rise to 2 lakh rupees.
cost of the construction of the road will rise.
Yes.
It is-
Heard, Miss
Yes, Mia, your-
S.
Mia.
Bhuyar and counsel for the petitioner. As well as Mrs. R. Borar and standing counsel for NHI DCL. You'll appear for one also. Representative respondent number 1, 4, 5, and 6. As well as Mr. J. Srutiyal and standing counsel for KAC, appearing for respondent numbers 2 and 3.
3, 7, 8.
7 and 8. But you'll also appeal for 6 then.
6.
1 and 4, 5, 6. Okay, I think this is complete. At the outset, the learned standing counsel for the KAC has submitted that person to order dated 9/6/2023. The Sri Tenzing, TENSING, Rongpi, the Joint Secretary, Department of Revenue, Karbi Anglong Autonomous Council, DIFU, is personally present.
Competent authority for land
Achha, and come, CUM, come. Competent authority for land acquisition within bracket CALA, Kala, is personally present. And that an affidavit in opposition is filed on 15/6/2023 to bring on record that he has already submitted
three
capital A documents in respect of 5 numbers of villages for alignment in Karbi Anglong district under National Highways Act, duly verified by what is the ARO?
Assistant Revenue Officer.
Verified by Assistant Revenue Officer, what is SK?
Survey Kanungo.
Survey Kanungo and concerned village survey mandal under the full revenue circle. I just flag mark, which was sent to the general manager within bracket P, NHI DCL,
Respondent number.
within bracket respond number
6.
Respond number 6. First of all, it is submitted that duly vetted notification under section 3A of the National Highways Act was also sent, right? 3A,
3 capital A.
here, page 68.
Page 68.
You are writing on the top, duly vetted notification.
Duty vetted, it is vetted from.
No,
by
whatever,
co-
so it's sent to
Sent.
them.
Okay,
Okay,
them.
already also been sent. First of all, accordingly.
After
it is
joint
sent-
verification. That was-
After joint verification
Which NIC DCL.
with NHI DCL. No, after joint verification of the site,
Oh,
along with NHI officials of NHI DCL. Next paragraph. Acha, what about this dispute about residential and this?
Commercial that has been made commercial, my
Commercial,
lord, that
okay.
after verification.
Okay, first of all, it is also submitted that that
Nature of the land.
initially the nature of the land of the petitioner was shown as residential, and after joint verification, the said land has been categorized as commercial. Next paragraph. In case of the petitioners is just right, bereft of detailed particulars, it would be sufficient to mention that the petitioner projects himself to the owner of a land measuring 1 bigha, 1 katha, 9 lechas, equivalent to 0.1097 hectare, covered by Dag number 65 under periodic patta number 3, situated in village Langtibuk, LANGTIBUK, block number 2 of Moza Borjan, BURJN, under Dipu Revenue Circle, KAC, and that the NHI DCL Under the central government, to the Ministry of Road Transport and Highways, along with NHIDCL, is undertaking a process of acquiring land alongside NH 29 for widening oblique four laning LANING, etc. of the said highway. Wide notification dated 22/1/2021. Full stop. Petitioner claims that the land of the petitioner was shown as residential, whereas it was commercial land. Full stop. The grievance of the petitioner is, although an objection was submitted on 9/12/2021 to the CALA, but the authorities are proceeding with the land acquisition process without making necessary rectification in respect of the class of land of the petitioner. Full stop. Hence this declaration. Next paragraph. As submitted by the Learned Standing Council for the KAC, that the land of the petitioner has been verified along with the by the Joint Secretary Kala through the departmental staff and the NHIDCL authorities. The classification of the land of the petitioner has been rectified, but the land required to be acquired has been reduced to. It has been reduced to.
Not reduced, madam. It was earlier also 0.08381, Lordship may page 67 of our affidavit.
Don't write anything.
Over area of compensate 0.3.
It is also submitted that the requisite documents under 3A of the National Highways Act, along with the vetted notifications, have been sent for publication. Now, the court is of the considered opinion that in view of the contents of the affidavit filed by the Joint Secretary, Department of Revenue, KAC Kala, even bracket respondent number
Response number
3.
3.
Respondent 3. The grievance of the petitioner has been redressed as the class of land has been rectified from residential to commercial. So accordingly, it appears that nothing survives for adjudication on this writ petition, and therefore this writ petition stands closed on satisfaction. First of all, the as the proceedings are closed, the personal appearance of the respondent number 3 is no longer required.
With due permission, your lordship, item number 51, that is a contempt case, your lordship, as the Joint Secretary Kala is here, your lordship. This case has been.
Yeah.
Yes, your lordship. In this matter, your lordship, the Honorable High Court has directed to the Competent Authority of Land Acquisition, Kala, your lordship.
He is an accused in, is a respondent in a contempt petition.
Yes.
My lord.
She is making some summation.
Yes,
Try
sir.
to understand
Item
that.
number 51, your lordship.
Item number?
51.
Notice has not yet been issued, my lord, contempt petition.
Oh, then I can't do anything.
Notice has not yet been issued, my lord.
Okay. Yes, 61 to 63.
Organized budget.
This matter would consume some of the time, my lord.
And I believe my learned friend and our party, my lord, they also have some urgency involved in this matter. my lord. So as per your lordship convenience, any convenience.
No, because you
date,
see,
my lord,
the convenience is not there.
my lord.
But I can just extend the sitting time and take the hearing because I have no other alternative. Every day it's a
Yes, my lord. I
same business.
support, my lord.
So I can start hearing.
Please, my lord.
If I start the hearing, then only it will conclude.
Yes, my lord.
The convenient time, if you say, every day is a convenient time for me.
Yes, my lord.
I sit normally plus one minus what do you call 1 or 2 minutes plus or minus
Yes.
at 10:15 and positively get up even after the court time. So therefore, my convenience is not the factor. If you start arguing, you start arguing.
My lord, then I can start with the preliminary, my lord, the background of the case, my lord. Lordship, I kindly take up item number 62, my lord, if it is not inconvenient. 62, my lord.
There was one more request for an upgradation of the matter.
Yes.
I may take up that and no other matter. Others can. Yes, Mr. Das.
67. The updation SC discharge.
Yes. I may take up that.
place for a few minutes.
Okay.
There is an IA. I'm applying for question number 14. IA is going to be served to me. Their petition is against me. Private number 14. And
Just let me understand Mr. Das first. We'll come back to you. Take a note that the copy is not served. Mr. Das want to say something. I.
There was a consent to establish a tea factory in the locality. So this was, my lord, Withdrawal. Page 35.
Yes, I'm there.
Yes. My lord, consent to establish was issued to your unit by so and so. Whereas a public complaint against your unit has been received by this office from so and so and 20 others, whereas another written complaint together with photographs was received from Sri Tilak, Pakwal, Setri and 47 others, white lettered himself. This complaint was also placed before the Deputy Commissioner, Sonitpur District Tea Board, Tezpur, Honorable MLA so and so, as well as Honorable MP so and so. Whereas PCBA Tezpur visited the site on so and reported that one private school and health sub-centers were observed at a distance of approximately 200 meters from the site. This information was reflected in your applications and so. Now, therefore, under the above facts and circumstances, Pollution Control Board Assam is constrained to inform you that you have not disclosed all facts and figures, thereby misrepresenting the situation nonchalantly, violating the provisions of law. Therefore, in exercise of power conferred on the so of the Act, the consent to establish order granted to you white order in reference is withdrawn. Has your lordship seen, ma'am?
Yes.
Then thereafter, it was again, my lord, hereby revoked. This order was revoked. Next page, my lord, 36. My lord, I am not on anything else. Page 36.
Yes, I'm there.
Here. Now, there is a section 31 where there is a provision for filing appeal within a period of 30 days, or my lord, if there is delay, then we can explain the delay. But we'll file appeal against the order because the locality, my lord, if the industry is set up, the locality is going to suffer a lot. So therefore, that appeal, I think the right, if your lordship allows me to, I seek permission from the court to file appeal under section 31 of the Prevention and Control of Pollution Act 1981.
Okay.
Appeal your lordship can be say provision. So that is good enough, my lord. And if I file appeal within a period of 10 days, they will consider within a 2 weeks or so after hearing us.
Without the petition.
And for a student for the faculty opinion, firstly, there is an appeal provision. Secondly, the person who had complained, they were the person who had given consent. And in the vicinity of 200 meters, there are other factories. Borsati factory. In the earlier petition, I have mentioned it.
the other factories already have taken loan of more than 3 crores, and all the factories are already established. We are about to complete. And there are other factories with the same vicinity for certain company. In the earlier petition, which I have filed in WPC 5453, it is mentioned there are all these things. Because
Please proceed. I'm hearing you.
I was not supplied to me, and the petition which was supplied to me, all the pages are not there. It's not comply with this court record. So I mean, furnished with a copy of the petition and the IA. Without hearing me, I'm the sufferer because I'm the respondent of 14, private respondent of 14. The applicant is against me. But without hearing me,
Mr. Gogoi, the difficulty is that we are not hearing. The difficulty is that we are not hearing. Mr. Das wants to withdraw it and go to the appeal. Correct. We are not hearing the matter on merit, but yes, Mr. Das, give a copy of the writ petition. Ask your.
Let writ petition be pending, but on the basis of the IA file by me.
No, the two things can't go together.
Yes.
Just give him a copy since he's the appeal. Ask your Mr. Engineer to give him a copy. Oh, so you have come back. Yeah, very good. Mr. Das, I congratulate you.
I had a point.
It is good to have somebody with you at your side.
My lord,
Very good.
somebody is missing your privilege.
Huh?
Somebody is missing your lordship privilege.
Can't help it. But I'm expressed my Mr. Das, I'm expressing my gladness. You are so worried. Why? You're not worried. He's in a pensive mood.
Because his son is a doctor now, my lord, serving as a doctor.
So here everybody knows everything. Very good. Then we close this writ petition entirely because I can't give that.
Well, the appeal provision is there. I'm just.
But Mr. B. Das, one senior counsel, assisted by Mr. I forgot the name.
What's your picture?
Mr. Das, counsel for the petitioners, and also heard for government who was there. You're there, government advocate? No, for the government, Mr. C.K. Barua. Mr. C.K. Barua, the government advocate, appearing for respondent number 2 and 10. Environment Forest, Mr. R.R. Gogoi, the standing counsel for Forest Department, appearing for respondent number 1. Industries, who is appearing? Anjan Kalita. So A. Kalita, standing counsel for Industries Department, representing respondent numbers 2 and 3. Pollution Control Board.
S. Borua.
Mr. S. Barwar, and standing counsel for Pollution Control Board, appearing for respondent numbers 5, 6, and 7. Zilla Parishad. Zilla Parishad, who appears? Panchayat PNRD. Oh, Mr. S. Chutia, standing counsel for PNRD. No. Oh, and Bora. Standing counsel for PNRD department, if paying for respondent numbers 9, 8 and 9. Keyboard is CGC. Oh, okay. You're not appearing in the matter. And record your name? No. Okay, okay. Agriculture, you are there? Mr. V. Chaudhary, standing counsel for Agriculture Department, appearing for respondent number 13. And Mr. S.R. Gogoi, counsel appearing for respondent number 14. Next paragraph. At the outset, the learned senior counsel for the petitioner has referred to
Section 31.
no, this 36 has referred to
35. 35 and 36.
referred to letter dated 21/6/2022 issued by the member secretary, Pollution Control Board Assam, whereby the consent to establish order granted to the respondent number 14 was withdrawn. And by a subsequent communication dated 19/11/2022, the said authority had revoked the withdrawal of consent to establish. Both the documents are appended to IS Civil 1636 of 2023. In the said connection, it is submitted. It is fairly submitted that under the provisions of section 31 of the Air within bracket Prevention and Control of Pollution bracket close Act 1981, provision for appeal has been provided. Accordingly, it is submitted that leave be given to the petitioners to withdraw this petition and to approach the competent authorities in the to approach the appellate authority in terms of section 31 of the said act. First off, said prayer is considered and allowed. This writ petition along with the connected IS Civil 1636 of 2023 is permitted to be dismissed on permitted to be withdrawn, therefore dismissed on withdrawal. However, aspirate for liberty is granted to the petitioners to approach the appellate authority is so advised.
That we will file the appeal within a period of 10 days, whether that will be disposed of within a period of that.
Then I won't say
that has to be given, otherwise we will not get it.
If such an appeal is filed within a period of 2 weeks from today, the said authority shall enter in the same and pass appropriate orders as expeditiously as possible in accordance with law.
Not beyond 2 months.
I'm not saying that. I don't know how long.
Expeditious, the word is not 1 month, that some judgment is there. When you
No, you see, Mr. Das, I am finding it very difficult now. You see, the presumption can be drawn under section 27 of the General Process Act, even in 30 months, 30 days.
30 days, yes.
So at times I find it very difficult to give a shorter time because you don't know.
Provide within a period of 6 weeks from the date of receipt of the appeal. Because in the meantime, if they construct it, it's
already finished factory.
No, I've said as expeditious as possible.
That would.
Because we don't even know how they are functioning. Since I've never been there, I don't know how they are functioning. Yeah, I'm sending you back this.
Obliged.
46. So in this case, final complaint has been filed on 14/6/2023.
After the statutory period or before it?
No, no, within statutory.
Within statutory
Yes.
period.
One,
It's possible.
170.
178 days.
Yeah, whatever. Mean.
Let the petitioner is behind the wall. As on date, my lord, 181 days.
Okay, your name is Reddy Roy.
A Rashid.
A Rashid, okay. I will say A Rashid, let me counsel for the petitioner. At the outset, Mr. S.C. K. Learned, standing as a learned counsel appearing for the
NCB.
National Crime Bureau.
No, no, for narcotic control.
Achha, Narcotic Control Bureau, Narcotic Control Bureau, representing the respondent, has produced a photocopy of the title page of
Complaint page.
final complaint submitted before the learned special judge Kamrup Amingao on 14/6/2023. To start with, it is submitted that the petitioner was arrested on 19/12/2022, and accordingly, the final complaint has been filed within the statutory period of 180 days. Postal. Accordingly, as the final complaint has already been filed on 14/6/2023 in respect of the offense, alleged offense committed by the petitioner, namely Monirul Islam, MONIRUL Islam, the present bail application stands closed by granting liberty to the petitioner to move the jurisdictional court for
My
bail.
lord, already 181 days, my lord. So my lord, he may be allowed to go on bail, my lord, to prepare his defense, my lord.
No, I can't do it.
Otherwise also, my lord.
I can't do it. You can show me an authority that after filing of the complaint, we can still continue with this application. Because it will be now jurisdictional court where the charge sheet has been filed. That is what I understand, subject to how you convince me.
My lord, since investigation is completed, my lord, there is nothing to investigate, my lord.
Oh, don't worry,
Always, my lord.
correct. Because if I make some observation, it may go heavily against you. I would not like to do it. Correct. Just because you have made some request with a smile. I won't put any disadvantage in your case, correct? You just see a few paragraphs of Satyendra Kumar until you'll understand. You read post 436A CRPC, you'll understand what I'm trying to
Yes, my lord.
tell you. Without saying it. I want to tell you something without saying it, correct? Just go through it. Yes, now we start this. Other matters I may not take up today. I won't have time.
My lord, the item 31, my lord. From our side, my lord, it's matter is that who considered dispose of at an early date. May I pay for my lord listing any day before
Yes.
vacation, my lord?
One by one, just tell the court master, give a slip.
My lord,
We'll make some adjustments.
my lord.
Item number 36, my lord, may be taken on 22nd, my lord.
I'm not saying anything. Let the court master decide.
Lordship.
Give a slip. you will
My
consider.
That slip I have.
My lord.
Published.
Regarding item number 28 and 29, my lord, can it be taken up on 24th of July, my lord?
July is no problem.
Yes.
Giving a date in July is no problem.
Yes, yes.
Only
That
before,
will be fixed.
just after some time, we just give one by one this slip, he'll make adjustments.
In item 42, can it be fixed on next Friday? Because it is a case of mercy and the consult.
Oh, acha, mercy petition, okay. Mercy petition, that your item is recorded
42,
42,
next Friday, my lord.
next Friday, okay. You can make a prayer for upgradation of that matter. Just inform the APP in
All right,
prior to that. Before you make a mention upgradation, you tell the APC.
all right. Let it be fixed on Friday, then
Okay.
we'll have to
Okay.
publish. Please, Lordship, item number 68, Lordship. One correction was there, Lordship, one line correction in the post title, Lordship.
Oh, cost title, you'll have to go to the registry and you file an amended petition, amended cost title. Because it has to be scanned and uploaded. Item,
68, Lordship, one respondent serial number is missing, Lordship.
no, but now there's a difficulty. We have you'll have to go and get it scanned, because otherwise we are facing difficulty. Because if the cost title is not scanned, it will not come in the what you call certificate copies. It has led to some administrative problems.
Lordship,
Correct.
I approached to the registry directed to file I, including that.
They have to do it because you see, you see, we are doing it till now, but some problem has cropped up. Because you see, now you can access the court records from anywhere in the world. There's an order adverse passed against you. Your name was not reflected in the cause list. You'll be angry. Why in the final order there's an order against me and the cost title is not amended? There are certain administrative problems which has cropped up. Please try to understand. You'll have to do it in that manner only, because this everything is being scanned and uploaded. So if your cost title is not scanned and uploaded, by pen you can't do a correction and expect that the central registry would be corrected. So we have now come to a decision that you'll have to file a document so that it can be scanned and uploaded. Everything is now in a short while. I think not even a year will 7-8 months. Everything will be digital. This files will no longer be there. Correct. So we are now adapting to a system where, because you see, what happens if you find your name in a case when you don't get the notice, what happens and the order sheet is not there. So therefore we are compelled to do it. Correct. You don't file an LIA, but I will permit you to have a scanned copy. Item number
68,
item 68. Your name?
R Islam, Lordship.
RH?
R Islam.
R Islam, counsel for the petitioner, submits that there is a typographical error which is kept in the cost title in respect of
Respondent number, respondent serial number supposed to be 2. Then I jumped to 4, Lordship. Three is
okay.
missing.
It is submitted that in the cost title, after respondent number 2, the petitioner has jumped to respondent number 4
4, 3 is missing.
without
Typographical mistake,
without
Lordship.
including anyone as respondent number 3.
Lordship.
And the error in the cost title, and for error of in the cost title, the petitioner, the land counsel for the petitioner seeks permission to correct the typographical error which is kept in the cost list. Full stop. On a consideration of the same, the petitioner is permitted to submit a scanned, submit a type, the amended what you call cost title to the registry, so that the data can be scanned and uploaded in the CIS system. And thereafter, the amended cost title be incorporated in the cost title. Full stop. The petition shall bring the order to the notice of the order of the filing section in the registry.
Applies.
Correct? Yes.
Lordship, before my friend starts, Lordship, item 61 is in relation to an NIT for a defined item, and 62 and 63 are a different NIT for a different item, Lordship. And that's the difference between the two.
Okay.
Lordship.
But the issues are same.
Yes, issues, Lordship, except for one condition, which they have SL, that the financial turnover that has been incorporated is much higher than it ought to have been. And others grounds are Lordship completely different.
Okay.
The facts are different, Lordship.
Okay.
May I?
Because if the facts are different, then we'll cannot take up together.
Of course not, Mano, but what I was suggesting, the main contentions that we have raised in the two petitions, Mano, are relating to
challenge made to a provision in the NIT, which introduces a clause which prohibits us from participating in the tender process. So this particular provision, we are saying, is palpably unreasonable, is arbitrary, and because of which we are prospective bidders, although we were duly protected by an order of this court, and court has observed that we should be allowed to participate. Now that entire repetition, my lord, boils down to only one issue, which your lordship would be pleased to take up, my lord, that whether this particular condition is palpably reasonable, sorry, my lord, palpably unreasonable, arbitrary, and it hits Article 14, and so on, my lord.
No, Mr. Bogdan, you're not following me. What I'm trying to ask you is that
My lord.
if on facts you go into venture into any other sphere,
Yes, my lord.
then it can't be taken up as a
Connected matter, my lord.
connected petition.
Correct,
So therefore, if you give up all of the plea and then only you are concentrating on one plea,
my lord.
then we can take it up. No issue with that.
But the facts are of course different.
The facts will be different, okay.
Facts of course different.
But the issue is only one.
Yes, of course, there's a simple
Okay,
issue.
then-
How about that?
But lordship, in item 61, the ground that for the reason that the financial clause condition was not in the initial NIT, but later on by corrigendum, it was brought into the
That is the
NIT.
facts are different.
Lordship, the ground for which it was not incorporated is completely different to the rest of the item number 62 and 63.
No, but basic facts is that only the insertion of that clause where
Yes,
he
but-
claims that he's ousted. That is the only issue
Yes, my
involved.
lord. There is the
But we'll take it up together.
difference is what, my lord, they have taken a different stand, my lord. That is what my learned friend is trying to say.
That's a
okay.
genuine stand, lordship.
No, it's
in,
okay. I'm not disputing
item
about
61.
this time. We are not going into that. But if that is the only issue, irrespective of the stand taken, the point is same.
My lord.
Financial clause condition insertion
Same.
that they have
You may have a
taken
different,
in both the NIT.
you may have different justification in other matters, but okay.
Your lordship is hearing me, madam?
Yes,
Yes, my lord. So may I submit, my lord? Kindly, or item number 62 may be taken up, my lord. 61, my lord. 62 may be taken up, my lord.
Yes.
Yes, madam. May I take my lord to item number 62 with petition 760 of 2023, my lord. Bidders, my lord. And your lordship will kindly come to the NIT which was floated, which we have annexed at page 17. Lord.
You see, this is number one. Before we begin,
Yes, my
two
lord.
things. Number one,
Yes,
this is a World Bank edit project,
yes, my lord, of course.
correct?
Yes, my lord.
The question to both of you is that is the tender condition